We have all of our committee members back. So we do have quorum, and we're going to get started with the second half of our meeting. And call to order this afternoon, 1:10 reconvene of the Cannabis Advisory Committee meeting. Before we get started, I just wanted to clarify for all of our committee members. After each presentation of each agenda item, please feel free. We'll open up the floor for discussion from the committee. We'll then open up the floor for public comment to the committee. And then committee members, you have the opportunity to respond to any of the public comments if you wish. So just wanted to clarify that as we go into this afternoon's agenda. We'll now open agenda item number 9, an overview of the regulatory process presented by Tamra Coulson.
Hi, thank you. We're going to talk about the regulatory process here. I just want to make it really clear, just so we all know where we're headed. Right now, we're talking about the procedure for the regulatory process. That's why you get a lawyer talking right now, everyone. So we're going to talk about that. In terms of the actual regulations themselves, that will take place in the update in the agenda item. This is an opportunity for us to provide some information to the committee as well as the public about how the regulatory process works, and in particular, the emergency regulation process that we're using for these regulations that you're going to hear more about later today, and many of you, I think, already have in your hands, so that you know what those points are, where you can participate and how to do it, and how to make sure that your comments become part of the record. So we're going to jump right into that, and we're going to first talk about what are regulations. You'll see up there we've got a really long legal definition, every regulation, order, rule, standard of general application, and it goes on and on and on with a big bunch of legal terms. But when you boil it down, what a regulation is it's a formally adopted rule. So if you're a licensee, a regulation is a rule that you would need to follow. And there's a formal process for adopting that rule. So what regulations do is they provide the detail to a statute. So you'll know that, and there's some places in MAU-CRSA where it says that you can sell something with a notation it hasn't been tested by a time set by the Bureau. So in the regulations, you're going to see that time. You'll see all the specifics for what needs to be in your application, the additional details that maybe aren't in the statute. So the rules are very important to the day-to-day operations. And in California, we have a very robust process for regulations. In California, there's a formal process, and it's referred to commonly as the rulemaking process because regulations are rules. You'll find that in the Administrative Procedure Act, and that's the government code that talks about how regulations must be developed in California. Whenever a state agency proposes regulations, they have to be submitted to the Office of Administrative Law for review. It's a state government agency whose sole purpose is to review and either approve or disapprove regulations proposed by California state government departments. Our APA's goals and what it accomplishes is to provide legal, valid, and clear regulations. It allows for meaningful public participation. As you'll see in this presentation, there are several requirements for the state agencies to give notice to the public at different junctures, and also it allows for public access to the regulations. So there are two ways to adopt regulations in California. We have what we call emergency rulemaking and regular rulemaking. The main difference between those processes is the timeline. We're going to talk first about emergency rulemaking today. That is the process that's going to be used for those regulations you've got in your hand right now. And this process is being used by the Bureau as well as the California Department of Food and Agriculture and the State Department of Public Health for their regulations related to cannabis regulation as well. So we'll flip over to the emergency rulemaking process now. So this is used when there's an expedited need for rules to get into place rather quickly. For example, a short timeline to get a program up and running. And actually, the Medicinal and Adult Use Cannabis Regulation and Safety Act, which we all like to call MAU-CRSA, it deems regulations to implement it as an emergency. So what that means is there's already been a decision by the legislature that these regulations need to go into effect quickly, and that they need to do so for public safety and health. In other situations, when it's not in the statute, the State Department has to make a factual showing of that need. But in our case, the legislature's already made that determination. So this emergency rulemaking process that we're going to be using, it's what's going to allow us to meet that statutory mandate to start issuing those licenses by January 1, 2018. The current statute that you all are going to be living by and that we're adopting regulations for just went into the effect at the end of June this year. It merged the medicinal and adult use regulatory systems. So there were a lot of changes, and we had a very short time to get all the rules in place so that we can all start January 1 when state licenses are needed. So this next slide, it shows a quick timeline of the emergency rulemaking process. So the first step in the process is advanced public notice period. So you've all received, I'm sure many of you are on our listserv, so you may have already received a blast about it. If you're on the mailing list, you probably have some mail waiting for you, and some of you picked things up today. And what that requires is that the state government agency gives at least 5 working days notice to the public of its intent to move forward with an emergency rulemaking action. So that's 5 working days where you get to see the text, you get to see the finding of emergency, which explains what we're about to do, before the formal comment period begins. It gives you a little time to think about what your comments are going to be and get them together. Once you've made it through that period, when we submit the emergency regulations to the Office of Administrative Law for the approval or disapproval process, day 1, when we submit them and it goes up on their website, that's when the public comment period begins. The public comment period for emergency regulations is quite short. So you want to make sure that you're calendaring that date if you want your comments to be part of the record. It's a 5-day public comment period, and that is calendar days, not working days. So, and depending when they're noticed, that deadline could be on a Saturday or a Sunday or a holiday. So that's day 1. It's a 5 days. By the 5th day, the public comment period closes. Up until the 8th day, the different departments can file responses to comments, although they're not required to do so. And then by the 10th day, the Office of Administrative Law will approve or disapprove the regulations. We'll move over now to if they're approved. So when they're approved, they would go to the Secretary of State and go into effect. We'll talk a little bit about just what the action's going to look like. You'll get a notice letting you know what we're going to do. If you have your packet, at least from the Bureau, your notice is the first 2 pages right there. And that notice provides you information as where to send your comments and who to contact at the agency if you have any questions about the action. It includes next the finding of emergency, and it explains the action. And then it includes the proposed text of the regulations, the actual language of what the rules we intend to propose are going to say and potentially adopt. Now we'll flip over to talk about the public comments themselves. There are some very specific requirements for public comments in an emergency rulemaking action, and I've got them up there, and they're important to note because you have to follow these rules for those comments to be an official part of the record. So 1, the comments must be in writing. They must state it's about an emergency rulemaking action at OAL for review and the topic of the emergency. So obviously for the Bureau, that would be cannabis regulation. They must be received within the comment period, which is that 5 calendar day period. I've got in red there just to kind of highlight that if you send in comments before that official 5-day period starts, like right now, they won't be considered as formal comments. And if they come in after that 5 days, they will not be considered formal comments in the record. So next, we'll talk a little bit about how the Office of Administrative Law reviews the regulations. They're going to look at the regulations to make sure they meet the definition of emergency, whether proper notice has been provided. They'll review the public comments and make response and any responses that are filed. And then they're going to review the text to make sure it's clear, it's necessary, we have the authority to do what we're asking you to do, and that we're not duplicating other rules that are already in place. The next step would be OAL approval. Once they're approved by OAL, They would then go to the Secretary of State, and they would become effective on that date or another date specified. The emergency regulations can be in effect initially for 180 days. We're able to adopt them for another 180 days, so therefore they can be available for 360 days as valid regulations. But they cannot be in place any longer than that. So what happens next is once we put out the emergency regulations, we are required to go through what's the regular rulemaking process. So once our emergency regs go into effect, we will then turn around and start the regular rulemaking process. And that's the process, if you've been involved, you're probably most familiar with. And those will be the regulations that will be in effect basically long-term until we amend them or change them or add to them, and there's no time period restriction on that. That process is a much more robust public participation process. So in that process, once we release the proposed regs, there's a 45-day public comment period. That's where we'll have the public hearings. I think many of you attended our public hearings for the original proposed regs under the Medical Act. So we'll do that again. There could be additional public comment periods if we make changes. And then we will be required to respond to public comments. So that's essentially rulemaking in a nutshell and how we'll be proceeding in the next few weeks and then throughout the next year as we move forward to replace our emergency regulations from all three of the licensing authorities with more long-term regulations, which this advisory committee will be very involved in that process. So we'll expect many of you might be at those meetings as well. The one thing I do want to just highlight for you, the one difference for emergency rulemaking as opposed to the regular is that your public comment needs to be sent to the Office of Administrative Law as well as the licensing authority who's proposing those regulations. So you need to make sure it goes both places. If you look at your notice, that's the top page of the packet from the Bureau, the first page or two, it gives you the information about where to submit it, both to the Bureau and at the Office of Administrative Law, so you'll know where you can go for that. So I think that's the overview. Are there any questions or comments? Yes, sir. Yes, sir.
So question for council.
Yes.
If I understood you correctly, and maybe I didn't, for the 5-day comment period, we are counting the Thanksgiving holidays as calendar days. So we don't extend for that time, correct?
Yes and no. That's a good lawyer answer for you, right? So
I expected it depends, but that's
yes, now and let me explain that. So the 5 working day prior public notice period that we gave you today starts today. So that 5 working days, the days of the holiday wouldn't apply to that period. The 5 calendar days start when we submit the regulations to the Office of Administrative Law. That period has not started. So from today, there are 5 working days before we can submit to the Office of Administrative Law, and that will carry us through the Thanksgiving holiday. So actually, there'll be a little extra time for those folks looking at the regs and getting ready for that initial 5-day formal comment period, which is in fact calendar days.
Thank you.
Sure.
Any other discussion from the committee? We will now open public comment for this agenda item 9, Tamra's overview of the regulatory process.
Mark Whitlow, Collaborative Incorporated. Can you just tell us what the days are?
Sorry, sir, can you speak a little bit closer to the microphone during the
Sure. Mark Whitlow, Collaborative Incorporated. Can you just tell us what the days are or what they're projected to be? So, when's the comment period? From what day to what day?
That's determined by when the Office of Administrative Law posts on their website our action. So I can't give you the exact date at this moment, but it will be, the 5 working day period would go through the end of the Thanksgiving holiday, that Sunday, so it would be sometime after that point, but I don't know the exact day.
So what should we monitor to find out when those days are?
I think the Cannabis portal is a great place to look. the Office of Administrative Law website and any, listserv announcements from the Bureau
So
or
it
the other
will come
licensing
through the
authorities.
listserv when that has been submitted and the dates with it?
So it will be posted on the OAL website, and I think you can anticipate we'll make sure that everybody will know when that period starts.
Okay.
We'll do our best to get the word out.
Hi, Ray again. Hey, Ray again. Will the public comments be published so that we can get to see what public comments were made on the regs?
They won't be, the law does not require it to be the same formal response that's done for regular rulemaking, the way we have to post all those comments. But anything that actually is part of the rulemaking file can be available for the public.
And will be?
You can certainly request that, and I assume that we'll be posting, anything we file on our website.
And I would do that through this process or just a regular request for information?
If you're on our listserv,
Yeah.
you're already going to get anything we would send out for notices. You can also request notice just on regulatory matters, but if you're on the listserv, you're going to get that as well.
Great, thanks.
So I don't know if there's any more public comment for the committee.
Hi, I just had a few questions about the cultivation. So I know that there is a canopy in which there's a designated
Excuse me,
area.
ma'am. This public comment is just on the regulatory process
Oh,
right
okay.
now. Okay.
Just the process?
Yes, thank
Okay,
you.
So can I ask questions later? Or?
There'll be opportunity for public comment
Oh,
about the regulations during that presentation.
okay.
It's not necessarily a question and answer situation, but it does allow for public comment.
Okay, thank you.
If there's no further comments, we'll move on to agenda item 10A. And 10A is a California Environmental Quality Act process overview by Michael Stevenson of Horizon Water and Environment.
Good afternoon, everyone. My name is Michael Stevenson, and as she mentioned, I'm with the company Horizon Water and Environment. We prepared the CEQA documentation in support of the Bureau of Cannabis Control and their regulations, as well as the environmental documentation for CDFA's licensing program as well. The purpose of my presentation today is to provide you an overview of that environmental process and the Bureau's initial study and negative declaration that they prepared pursuant to the California Environmental Quality Act. The California Environmental Quality Act, or CEQA as people call it, is one of the landmark pieces of environmental regulation in California. It was passed in the 70s, and what it essentially requires is that public agencies identify the significant environmental effects of their actions and take steps to reduce or mitigate those environmental effects. Public agencies comply with CEQA whenever it undertakes an activity that is considered to be a project. And a project is a discretionary action, something that they have some sort of decision about, and something that has conceivably could have an impact on the environment. The Bureau, their regulations are considered a project, and so they need to comply with CEQA before those regulations can be adopted. So we started our environmental analysis with what's called an initial study. An initial study is a preliminary evaluation that's conducted by a lead agency to determine whether or not there is a potential for a significant environmental effect. It aids in determining what type of environmental document would be prepared, whether that's a negative declaration, a mitigated negative declaration, or the highest level of CEQA documentation, which is an environmental impact report. The Bureau is looking, in their environmental analysis, the initial study looked at the actions that are subject to their regulatory authority. And that includes transportation, distribution, laboratory testing, and the microbusiness license type, which is a license that covers, it's a vertically integrated license, which includes retail sales, manufacturing, and distribution. Or, I'm sorry, cultivation. So as part of preparing the environmental document, we Went through a lot of different steps. We conducted site visits to various facilities that are in operation today, cultivation sites, manufacturers, dispensaries. We did tribal consultations under CEQA. There's a requirement that lead agencies consult with tribes on any potential effects that their actions could have on tribal cultural resources. And so we got a list of all the tribes in California. We sent a notification out to those tribes about the project and received responses back, many of whom wanted to consult, and the Bureau engaged in formal consultation regarding the potential effects and the concerns that the tribes may have. We considered a number of past, existing, and probable future actions which could combine with the effects of the regulations and the licensed activities to cause what's called a cumulative environmental effect. And that includes baseline activities related to cannabis, whether it's ongoing cultivation, existing retailers, distributors, testing labs, et cetera. We also relied upon the Department of Food and Agriculture's environmental impact report. So they prepared an environmental impact report for their cultivation licensing program. For the purposes of evaluating microbusiness and the cultivation that would happen under a microbusiness license, we determined it didn't make any sense to redo the analysis that Department of Food and Ag had already done, because they had already looked at that in great detail. So we incorporated that information and referenced it in the environmental document. The study primary focus is really on activities that are subject to the Bureau's licensing authority. Like I was saying, testing, retail sales, et cetera. It did not look at other activities which are outside of the Bureau's regulatory authority, whether those are cultivation sites that would be licensed by CDFA, manufacturers that would be licensed by the California Department of Public Health, illegal activities that are happening on federal land or elsewhere, really focused in on the activities that the Bureau oversees. And specifically those activities as they would be conducted pursuant to a license in compliance with the regulations that the Bureau is going to be adopting. Even beyond that, we also looked at an extensive range of existing state and local regulations that would apply to these business types, whether those are workplace safety requirements of Cal OSHA, requirements of the State Water Resources Control Board, California Department of Fish and Wildlife, rules related to management of hazardous materials. There's all sorts of different regulations which are already in place which would apply to these cannabis businesses. And so we considered the potential for impacts in the context of that. If people are following existing laws and regulations as they're required to under Mount Cursa, would there still be a potential for an environmental effect? So on that basis, we determined that there's a number of environmental resource topics where there was really no potential for these types of business activities to have a significant effect on the environment. And so you can see the list of activities that we dismissed. We determined, based on the consultations with the tribes, that there was no real potential for impacts on Native American resources, sacred sites, et cetera. We would not be having adverse effects on mineral resources or the availability of those mineral resources in the state. We would not be having adverse effects on agricultural lands because these activities are primarily in urban areas and within existing developed sites. So we concluded that all of these things really had no potential for an effect, and so we did not examine these in a great level of detail. And in some cases, the potential for a significant effect was covered by the CDFA EIR. So an example of that would be agriculture. Effects on agriculture were considered for cultivation through that other EIR. This is the list of environmental topics that we did look at in more detail because we determined that there was some potential for a significant environmental effect. And that includes aesthetics, so the potential for, now most of these activities would happen inside enclosed structures, out of the sight of the public, but there would be public views, whether it's a retail sales establishment, a dispensary, a microbusiness that may have some sort of cultivation site associated with it. We looked at the potential for there to be aesthetic impacts from lighting or just signage, other things that the public could view. We looked at potential air quality effects, whether that's odors, perhaps from the cannabis products themselves or from the processes that are used to produce them. We looked at the potential for air emissions, air pollutant emissions from the use of fossil fuel combustion as part of the equipment, maybe vehicles that are used for deliveries or backup power generators, et cetera. We looked at the potential for special status species and habitats and sensitive communities to be adversely affected by these business activities. We looked at energy use and GHG emissions, and again, this was really looking at the equipment that's used, especially for the micro-business. Cultivation, indoor cultivation will use high-intensity grow lamps, and so looking at what sort of energy footprint that would have. We looked at hazardous materials and human health. So as part of the CDFA EIR, there was a detailed evaluation of the human health effects of the potential for use of pesticides on these products, those pesticides that are allowable for use by DPR, as well as other chemicals, workplace hazards, those types of effects. Noise, the potential for these activities to generate noise, whether that's vehicles, equipment, other things. Public services, we primarily focused on fire and police protection and ensuring that operators would be using appropriately, following the building code for electrical standards, wiring, that type of stuff. And transportation and traffic, whether there'd be a substantial effect due to traffic generated with these different license types. And that might include people coming and going from a retail sales establishment, the businesses themselves transporting products to and from different licensees. So for these environmental impact topics that we did evaluate in more detail, we did determine that they would either have a no impact or a less than significant impact on the environment. And so on that basis, the Bureau filed what's called a negative declaration, or an ND. So a NEGDEC, negative declaration, is the environmental document that is prepared following the preparation of the initial study that outlines the Bureau or the lead agency's determination that there is not a potential for a significant effect on the environment. Significant effect on the environment, this is kind of a lengthy definition here, but it's a substantial or potentially substantial adverse effect on physical conditions. And considering all those different resource topics that I described earlier, either those dismissed or those considered aesthetics, agriculture, air quality, biological resources. So we determined there really is no potential for a substantial adverse effect related to those topics. That negative declaration, or at the time it was a proposed negative declaration, that was circulated to the public for 30 calendar days. That public review period began September 6th and ended 30 days later on October 6, 2017. During that period, we held 3 public meetings in different locations throughout the state in order to solicit public comments and talk with people. They were in a workshop format, so we were able to interact, staff and consultants were able to interact with members of the public, answer questions. We received 50 public comments during the public review period. The majority of those did not relate to the environmental analysis itself, but were much more focused on aspects of the regulations, whether that was an interest in having there be mandatory testing for terpenes, other things that people were interested in seeing. All comments were carefully reviewed and considered, and a response to comments memorandum was prepared, which provided detailed responses to every comment that was received. And not just each comment letter, but within each of those 50 comment letters, we divided it into its individual comments and provided a response to each of those. So as the final steps in the CEQA process, the Bureau considered those substantive comments before approving the proposed program. And upon approving the proposed program and finalizing the process and adopting this negative declaration, the Bureau has filed a notice of determination with the State Governor's Office of Planning and Research CEQA Clearinghouse. And so that NOD, the filing of that NOD signals that they have completed their CEQA process and they can move ahead with implementing the project and adopting the regulations. That notice was filed on Tuesday the 14th. So they have now completed that to allow the adoption of regulations. So that concludes my presentation. Thank you.
Thank you, Michael. Any comments, discussion from committee members? Yes,
Am I to understand that there are separate CEQA reports?
Michael, sorry. Thank you. Question from the committee, right here.
Am I to understand that there are separate CEQA reports for the Department of Public Health and Agriculture and Food?
Yes, they, as separate lead agencies, they're responsible for their own CEQA compliance.
additional comments, discussion from the committee?
Thank you.
Now we'll open public comment on agenda item 10A, the CEQA process. Great.
If I can ask a question, direct a question, how has CEQA dealt with the fact that the folks growing indoors with their 6 plants allowed, how are they going to mitigate the fact that those chemicals are going down eventually to our rivers and bays? I didn't see it. I didn't see that any kind of carve out for the chemicals that would be down residential drains. I say that because it's been brought up that this is CEQA exempt. And so I have already talked with an attorney that plans on challenging that, because that is probably the primary harm to our society, and it hasn't even been addressed.
Thank you for your public comment.
Okay. So I take it we have no response to that? Okay. Just wanted to know because we haven't seen it, and it hasn't been brought up. So.
Hello. I have a question about how the individual growers and the micro enterprise will be affected by CEQA, and whether they will individually be responsible for CEQA documents to submit and actually get permitted. Is that, it's not a comment, it's a question.
Yeah, thank you for your comment. You can certainly reach out to your local authority or the state licensing authority for if you have questions about your specific situation.
Okay. And I was a little surprised by the hydrology part as well. I would tend to disagree with that. Thank you.
We'll move on now to agenda item 10B, the emergency rulemaking updates. A few announcements before we get into this agenda item, as I know there's a lot of interest in this. One, you're seeing a lot of PowerPoints this afternoon. All PowerPoints will be on the Bureau website following this meeting, as well as notes from the meeting, the full video of the live webcast. The process we'll use for this agenda item is we'll have Lori Ajax, Richard Parrott, and Marion Klein, each from the Bureau of Cannabis Control, Cal Cannabis at CDFA, and CDPH, present on their emergency regulations. We'll then go to discussion from committee members, and then open up public comment for our committee members. Laura, if you want to begin.
Well, good afternoon. So now that our emergency regulations are released and they are on our website, I'm going to go through some of the highlights and some just an overview first, and then some of the highlights of our regulation for the Bureau. Paper one too, so I can do that if you want. Okay. Great, thank you very much. So the Medicinal and Adult Use Cannabis Regulation and Safety Act, as all of you know, it is the the statute that now has created a single regulatory system for commercial cannabis activity in California. It requires that all persons engaged in this activity must be licensed by the state of California, and it also allows local jurisdictions to control what activities are permitted in their jurisdiction. And it places the protection of the public at its highest priority. So starting on, important to know, starting on January 1st of 2018, everybody will have to have a state license in order to conduct commercial cannabis activity. So here's the structure of all the licensing authorities. The Bureau of Cannabis Control, we are the lead agency on this effort, and we will be issuing licenses for the distributors, the retailers, the micro-businesses, the testing laboratories, and the temporary cannabis event licensees. California Department of Food and Ag will be issuing the licenses for the cultivators, and they will also be implementing the track and trace system. And then California Department of Public Health will be issuing the license for the manufacturers. Something to note, there's been a tremendous, over the last almost 2 years, a tremendous coordination between the three of us, along with other state agencies. We talk, and just about every day, the level of coordination has just been incredible. And I just want to say it's been a pleasure working with the other two agencies. So, thank you. We're almost there, right? So we are the lead agency in developing these regulations, and I do think it's important to know that the goal is to regulate in a manner that protects public safety and public health by ensuring cannabis and cannabis products are safe for consumer and sold in a manner that it restricts access to minors. So that is really the ultimate goal for the state regulatory system. So here's what it's going to look like on January 1st, 2018. The state is going to be issuing first temporary licenses. We have that statutory authority in the MAU-CRSA. For the Bureau, this is going to be submitted through the online licensing system. We will have a paper application available for those that want to use a paper application. We expect to have our online systems accepting applications next month. We want to take these applications ahead of January 1st, 2018, so we can start issuing licenses on January 1st. In order to get a temporary license, you must have a copy of a license permit or other authorization from the local jurisdiction. That is in statute. The Bureau is also requiring some other information, and we have all that information on our website. We have a handout, but it's all now also in the regulations that have been released today. So for the most part, that's what we were doing on January 1, is issuing those temporary permits. At the same time, if applicants want to apply for an annual license on our online system, they can. This can also be a paper application. We'll have that available. It's valid for 1 year. It must be renewed each year, and they have to be in compliance with the local jurisdiction's regulations and ordinances. So the Bureau can't issue a license if they are not in compliance with the local jurisdiction. So on the annual license, it'll be a more extensive application than the temporary, and we're going to be gathering information on the business, individual owners, financial interest holders, the premises, and the business operating procedures. That is obviously all in our regulations that you have today, what each licensee is going to be required for an annual application. So these are the license categories for all of the Bureau's licenses. You do have to get a separate license if you're going to be conducting medicinal commercial cannabis activity, and a separate license for adult use cannabis activity. So for each of these license types, depending on the activity, you'd get an A or an M or both. We've added some new license types, the distributor transport only, and the non-storefront retailer, the micro business, the cannabis event organizer, and the temporary cannabis event. Those were not in the Medical Cannabis Regulation and Safety Act regulations because those license types did not exist. So I'll be going over each of those license types a little later in our presentation. So some key requirements, the definition of owner, and this applies across all three licensing authorities. It's a person with an aggregate interest of 20% or more in the commercial cannabis business. It could be the CEO of a nonprofit or other entity, or a member of a board of director of a nonprofit. Or an individual who be participating in the direction, control, or management of the business. Somebody in the business has to qualify for an applicant, so we have to have somebody to license. All owners must submit fingerprints to the Department of Justice, and persons with a financial interest will have to be disclosed on the application. They won't have to be fingerprinted, but anybody with less than 20% interest will have to be disclosed. So for premises, each premises is going to require a license. For the Bureau licenses, only one licensee will be for each premise, with the exception of folks that are going to hold both an A and an M license, and they're going to conduct the same type of commercial cannabis activity. Then they can be on the same license premises. Now, premises is what the business defines as their area on the diagram. That doesn't mean you couldn't have a property or a parcel that has multiple licenses. What we're talking about is that you wouldn't have different licensees on the same footprint of the diagram. As most of you know, the statute requires that it cannot be located within 600 feet of a school, grades K through 12, daycare or youth center, unless permitted by the local jurisdiction or the state. We are requiring a premises diagram, and the landowner of the land must provide approval for using that property for cannabis activity. It is required that each licensee must have a $5,000 surety bond payable to the state of California to cover the cost of destruction of cannabis. And then all licensees are going to have to enter certain events into the tracking system so we can trace the cannabis throughout the supply chain. Records will have to be kept for at least 7 years. All of our records requirement will be found in the regulations. And something new that we have in our new regulations today is generally we have prohibited being able to give free cannabis goods, but we have made some exceptions. If you're a medical cannabis patient who has difficulty in accessing medical cannabis goods, they may receive free cannabis goods from a medical type retailer or a medical type micro business that has retail, is engaged in retail, if that patient or primary caregiver is in possession of a valid identification card issued pursuant to the Medical Marijuana Identification Card Program, which is handled by the Department of Public Health. Also, that cannabis goods have to meet all the testing requirements. In addition, we've allowed that licensees, the Bureau licensees, may donate cannabis goods or use of equipment as long as they're in compliance with any of the local jurisdictions' compassionate use or equality or similar programs at the local level. So as for the distributor license type, the distributor is the only licensee that is able to transfer cannabis goods between licensees. So if you remember in the Medical Cannabis Regulation and Safety Act, there was a transport license that is no longer in the new statute. So only a distributor can transport cannabis goods between licensees. They also arrange for the laboratory testing. They do all the quality control of making sure packaging and labeling is accurate before it goes on to the retail licensee. And they also are going to be storing cannabis goods. We did get a lot of comment. Folks, there's some people that wanted to be able to transport cannabis, but they did not want to do all of the distributor requirements like arrange for testing or doing the quality assurance. So we have created a distributor transport only license they're allowed to transport cannabis goods between cultivator, manufacturers, and distributors only. There is one exception. They can't transfer goods to retailer except for immature live plants and seeds being transported from a licensed nursery with the California Department of Food and Agriculture. So all of our distributors are going to have vehicles with alarms. Only distributors or distributor transport only licensees or their employees may transport the cannabis, and we are allowing that medicinal adult use cannabis can be transported together as long as it's clearly identified what products medical and what products adult use. And then all of them must generate a shipping manifest. So with all the required information is all outlined in the regulations on what is required for that shipping manifest. And that's going to have to be done each time that cannabis is going to be moved. So for our retailers, we have two different types of retail license. We have a retailer that will have a storefront, and it also allows delivery. So a retailer can sell cannabis goods to consumers or patients. Again, depending on what kind of commercial activity, they can get a medical license, an adult use license, or both. Non-storefront retailer, that is delivery only. They still have to have a premises, but it's not open to the public. So a licensee can have both, as we talked about earlier, both an A and an M on the same premises. The hours of operations are 6 a.m. to 10 p.m. All cannabis goods that are leaving the retail store must have exit packaging prior to leaving the premises. Deliveries can be done by either licensee, but it must be done by only an employee of the retailer, and they have to deliver to a physical address. We only allow a delivery vehicle to transport up to $3,000 of cannabis products during their delivery, and the retailer must be able to locate any of those delivery vehicles at any time when requested by the Bureau. So the microbusiness, the microbusiness was not in the Medical Cannabis Regulations Safety Act, so we have all the requirements for that. That allows cultivation up to 10,000 square feet. Manufacturing, level 1 manufacturing, it allows distribution and retail, and it's one license. And you could get either an M license or an A license for the microbusiness. And in order to qualify for a microbusiness license, you must engage in at least 3 of the 4 activities. You must indicate what activities on the application, and then you'll have to be in compliance with all of those activities. We will be working with both Food and Ag and Department of Public Health for the cultivation and the manufacture. So in order to get issued the license, you must be in compliance with all the requirements of the activities that the licensee plans to engage in. The temporary cannabis event licensee, that is to allow for temporary events on state fairgrounds only. The temporary event licensee is good for up to 4 days, and it allows on-site sale and consumption of cannabis goods. In order to get approval to conduct a cannabis event activity, you first must obtain a cannabis event organizer license. So once you get that organizer license, then you will submit an application each time the organizer wants to have an event on a fairgrounds. It'll allow for the sale of cannabis goods by a retailer or micro businesses that are engaging in retail activity. Access to the area where there's going to be sales and consumption is restricted to people of 21 years of age or older, and the consumption of alcohol or tobacco is prohibited. On-site consumption must be done in accordance with the local jurisdictions. They must approve that on-site consumption, and security must be present at all events. So the testing laboratories, so they're the only licensees that do not have to get either an A or an M. They can do both adult use and medical cannabis testing without getting that specific designation. So they're going to be collecting the cannabis good batch from the distributor's premises. They are going to, the laboratories are required to pull the random representative samples from the batch, and they're testing for all 10 different things there, and all those requirements is in our regulations. The laboratories, they're going to have there's going to be a lot of strict requirements for them. They have to be ISO certified. Our harvest batch and our manufactured product batch has changed. They have to take samples of a batch no more than 50 pounds, and for product batches no more than 150,000 units. They have to develop standard operating procedure, chain of custody protocols, and document all their transportation and handling of those samples, and they have to generate a certificate of analysis for the primary sample, and that goes to the distributor, and they must ensure that it is passed testing before it goes on to the retailer. So our licensing fees are now in our regulations. It covers the cost of administering the Bureau's cannabis program. The application fee for all three of us is the same. It's $1,000, and that is paid when the application is submitted. The only exception to that is the temporary application. There is no fee for the application, or there is no license fee. So that is the one exception. Our license fees will be payable once we approve the application. So at the time of application, it's only the cost of the application fee. Once we notify the applicant your license has been approved, we will then request the license fee. The Bureau scaled their license fees based on the maximum dollar of the licensee's operation. And there is a chart in our regulation, and you'll see that all of our license types have a scaled fee. The only exception to this would be the Cannabis Event Organizer, and that's based on the number of events they will have each year. So we also have this in our regulations because we want to have a smooth transition to the commercial market, and we know that once we start licensing people on January 1st, there's going to be a lot of product out there that doesn't meet the standards of our regulations. So I will go through what those transitions are. This transition is for 6 months from January 1st, 2018 to July 1st of 2018. And licensees may do the following. They may conduct business with other licensees, irrespective of whether they're an adult use licensee or a medicinal use designation. So they'll be able to do that for the first 6 months. They can sell goods and inventory that don't meet packaging requirements if it's placed in child-resistant packaging by the retailer. Non-edible cannabis products that do not meet the THC limits per package may be transported and sold. Medical licensee may transport and sell medicinal edible products that are 10 milligrams or less per serving, regardless of the THC level in the package. Cannabis goods that do not meet the labeling requirements may be transported and sold if a sticker with the applicable consumer warning statement is affixed to the package. Cannabis goods that have not undergone laboratory testing may be transported and sold if a label stating they have not been tested is affixed to the package. And dried flower that is currently in the retailer's inventory at the time of licensure can continue to be packaged by the retailer. And then any cannabis goods in the retail inventories that don't meet the requirements set by the Department of Public Health for ingredients and appearance can be sold, and it's important to know these are products that are already in inventory at the time of licensure, and this is for the 6 months period to allow transition. Also, our testing requirements, there will be required testing on January 1st, 2018. However, we have a phased-in process for all the testing requirements, and that will be phased through 2018. Our regulations detail the timelines and that phase-in period for our testing labs. And that, I will turn it over to Richard Parrott.
Okay, thank you, Lori. Good afternoon, committee members. I'm Richard Parrott with the California Department of Food and Agriculture, and I'm the director of the Cal Cannabis Cultivation Licensing Division. I'm pleased to announce that the CDFA's emergency regulations have now been released. The regulations provide the framework for state cannabis cultivation licensees. Our regulations are organized into 7 different articles as follows: definitions, application, licensing, site-specific requirements, records and track and trace system, inspections, and enforcement. Now, what I want to do right now is to just give a high-level overview of some topics that were from the previous medicinal regulations earlier in the year that have been addressed in these current emergency regulations. So, canopy. The definition of canopy has been revised to clarify that non-contiguous areas with identifiable boundaries may be included in the canopy calculation. This will allow spaces in between canopy areas to be eliminated from the calculation, and examples of identifiable boundaries have been added to the regulations. For mixed light, based on industry practices, CDFA has created 2 tiers for the mixed light category to differentiate between farmers that use supplemental versus high-intensity light in a greenhouse or hoop house setting. Temporary licenses, Lori touched on this earlier in her presentation. We added requirements for temporary applications based on changes to the law. Our regulations are in alignment with the bureaus as well as Public Health regarding the temporary license requirements. The application fees, CDFA will charge a fee for application for a cultivation license. We've updated the application fee schedule based on our current known existing costs to the department. The application fees were scaled based on the average annual production of the license type, and that is clearly identified in the regulation. For cannabis waste management, CDFA updated the cannabis waste management requirements in consultation with CalRecycle to be consistent with current state laws and regulations for waste handling, and specifically removes the requirement of rendering cannabis prior to disposal and clarifies the requirements for on-site composting using a waste hauler or self-hauling. For track and trace training requirement, I will touch a little bit on track and trace further in my presentation. What I do want to point out is that the track and trace system, temporary licensees will not be required to utilize the track and trace system. They will be required to document the movement of cannabis and cannabis products through paper invoices and manifests, which are clearly outlined in the regulations. The track and trace training requirement will require an applicant for an annual license to register for and complete training for the track and trace system within 10 days of receiving notice that their completed application has been received and approved by the department. And there are no associated fees with the required training. Our annual license fees have been updated. The license fee schedule has been updated based on current known existing costs to the department. License fees were scaled based on the average annual production of the license type. For cultivation, I do want to touch on cultivation license types. In addition to the licenses that are outlined in law, CDFA has added a license type for cannabis processors in the regulations. Processors will be able to trim, dry, cure, grade, and package cannabis from other licensed farmers, but may not grow plants under this license. For medium cultivation license limits, CDFA is mandated by law to limit the medium-sized license types and has specified that a person is limited to one adult use or medicinal medium license type. Renewable energy requirements. Department has modified the renewable energy requirements to allow a phase-in period. Beginning in 2022, licensees will need to provide details regarding energy use and sources. Beginning in 2023, licensees will need to meet the average electricity greenhouse gas emissions intensity required of their local utility provider. For generator requirements under the medical regulations, there was a proposed ban on generators. In the emergency regulations, the department has modified the generator requirements by specifying applicable generator types and requirements for allowable generator use based on those previous comments. And finally, for the track and trace system, as I mentioned earlier, temporary licensees will not be required to utilize the track and trace system. Annual licensees, the applicants for annual licensees will be required to take the state mandated training. Once they have received the training and are approved to use the track and trace system, the regulations call out specific timeframes for that licensee to establish themselves within the track and trace system and to order unique identifiers for their cannabis and cannabis products. I do want to note that the tagging of cannabis plants from the cultivators will happen in this fashion. Immature plants will be, cultivators will be allowed to have immature plants in lots up to 100 plants in a contiguous area. That lot will need to have a clearly identifiable unique identifier for that lot of plants. Each plant within that lot will be required to have a decal or an identifier on each plant that matches the unique identifier. All of those plants within that lot will need to be accounted for. For instance, if a plant within the lot does die off, the cultivator will need to account for that and track that information and keep adequate records to document that. Once the plants go into the flowering stage into the canopy, each individual plant will need to be tagged with a unique identifier that will be able to relate back to the original unique identifier from that lot of plants where the mature plant came from. And then finally, we have towards the end of our regulations, we have articles that touch on our inspection authority and enforcement, and also a penalty matrix that outlines any fines that may be imposed for violations. And finally, on this slide is our contact information with our website information. And that concludes my presentation, and I'll turn it over to Marin Klein from Public Health. Thank you.
Thank you, Richard. Good afternoon. I'm Marin Klein, and I'm with the Department of Public Health. I'm the Assistant Deputy Director for the Center for Environmental Health. And what I'm going to cover are our emergency regulations for cannabis manufacturing. So what is a manufacturer? A manufacturer is a business that is conducting extraction and infusion processes, packaging, and labeling of cannabis products. And what is a cannabis product? That's when a plant material has been transformed into a concentrate, edible, topical, or other product containing cannabis. And the role of the Department of Public Health is to protect public health by promoting product safety. Just like Lori indicated earlier, we are also going to be issuing temporary licenses. Those will be valid for 120 days. They could be extended for additional 90 periods as long as within the 120 days the business has submitted an application for our annual license. Our annual licenses are valid for 1 year. We are going to have an online application process for the annual license. We have a paper process for the temporary license. The form is attached to the regulations that we released today, and the form will also be available on our website. The annual licensing requirements include owners, financial interest holders, and then additional premise information that applies to manufacturers. Those are things like a description of the inventory control procedures for tracking all cannabis products, a description of quality control procedures, such as written sanitary operation procedures for the facility and the equipment, procedures to protect against allergens and cross-contamination of cannabis products, the transportation process, security procedures, and a description of the waste disposal procedures. The license categories, so A is going to be for adult use market and for medicinal, and a single premise can have both licenses. In addition to that, this regulation package addresses 4 types of licenses. Type 7 is for anyone who's going to be doing extractions using volatile solvents. With that type of a license, you can also do non-volatile extractions, infused products, and packaging and labeling. A Type 6 license is for extraction using mechanical or non-volatile solvents, infusion products, and also packaging and labeling. A Type N license is for a business that is only going to be doing infusion products or packaging, and a Type P is for businesses that are packaging or repackaging products. A Type S license, we have a placeholder in our existing regulation package for this 5th type of license, and it's for share manufacturing facilities. The requirements for this license type, those will be incorporated into a separate emergency regulation package that we are going to be releasing soon, and those licenses should be available early 2018. A business only will need 1 type of license, depending on what activities they are conducting, and a manufacturer that is holding one of these licenses can only manufacture cannabis products at the licensed premises. So our fee schedule is also in the regulations. We do have a $1,000 application processing fee. In addition to that, we have 7 tiers of licensing fees, and that is based on the gross annual revenue. Next. So volatile solvent and CO2 chemical extraction requirements, as you can see from there. Any hydrocarbon-based solvents, those must meet 99% purity. All of these type of extractions must be performed in a closed-loop extraction system. The professional closed-loop system and the facility must be approved by use by local fire code officials and must meet all required fire safety and building code requirements. A licensee cannot conduct volatile solvent extraction operation in an area that is zoned as residential. So product standards, there's a number of products that are not allowed. So alcoholic beverages cannot be infused with cannabis. This restriction does not apply to tinctures. Prohibitive additives include nicotine and added caffeine. This restriction does not apply to products containing naturally occurring caffeine like coffee, tea, or chocolate. No perishable products. These are things like that need refrigeration, except for juice of beverages, as long as those are processed and manufactured according to all of the requirements that we have in the regulations. No dairy products, except for butter that is purchased from a licensed milk product plant. No seafood products. No low-acid canned products. And a cannabis product cannot be in the shape of a human being, animal, insect, or fruit. THC requirements. So these are very similar to what we had introduced back in April when we released the medical cannabis regulations. For the edible products, the maximum of 10 milligrams of THC per serving. That's actually a requirement that is in statute. So in the regulations, we are adding a package requirement of up to or maximum of 100 milligrams of THC per package. Edible products that consist of more than one serving, those must be scored or marked clearly to indicate each serving. Other types of products, these are things such as tinctures, concentrates, capsules, topicals. These are limited for the adult use market. These are limited to up to or a maximum of 1,000 milligrams of THC per total package and a maximum of 2,000 milligrams of THC per total package for the medicinal use market. This was one of the areas that we received quite a large number of comments during our public comment period in April, so we made an allowance for the medicinal market. Packaging requirements. The package cannot resemble or imitate a package used for products that's typically marketed to children, and also cannot be easily confused with commercially available foods that do not contain cannabis. If a product is an edible product, the package must be opaque. Prior to release of products to the distributor, all cannabis products will be labeled and packaged in its final form. The package must be tamper evident, the package must be child resistant, and if the package contains more than one serving, the package must be resealable. Next. Labeling requirements. So if a cannabis product is intended for the medicinal market, it must state for medicinal use only. The label must include a list of product ingredients, food allergens, and nutritional panel. The label cannot use the term candy, instructions for use, such as the method of consumption or application, and cannot use content that is designed to be attractive to children, such as cartoons, characters, or phrases that are popularly used to advertise to children. Cannot use any information that is false or misleading, or any health-related statement that is untrue or misleading. It must include the THC and CBD content in milligrams per serving and per package, per total package. It must include the warning statement that is listed in statute in verbatim, and it must also include the universal symbol. So as you can see on the screen, this is the new universal symbol for all cannabis products. Next. Thank you. So, and lastly, the transition period. This is similar to what Lori discussed for the retailers. So for products that are already in the market or already manufactured and produced, if a manufacturer still has those products that have already been produced prior to January 1, they will be able to move those products as long as they are either in a child-resistant packaging, if they're primary packaging, or they can add a secondary package that is child-resistant, and they can add a sticker or a label with a government warning and the amount of THC. For manufacturers, and this only applies to manufacturers that are manufacturing a product on January 1 or afterwards, those new products must meet the THC requirements that we have included in the regulations. Next. Thank you. I know that was a lot of information to absorb at one point. Thanks.
Thank you. Now this is a time for our committee members. Any comments or discussion? Yes, please.
Thank you very much. There's a lot to review, and I'll probably have a lot more questions later, but there's a couple questions that piqued my interest from the very beginning. So, Ms. Ajax, I think the first couple questions I had to do with, since I haven't looked at the entire regs, do the regs, when it pertains to the 600-foot setbacks, does it account for if the business is there and has grandfather or standing, school, a daycare gets moved into the community, or some other type of school gets moved into the community, is there a standing for that business who was there in advance? So that would be one.
Yes, so it's at the time of licensure.
Okay. And then the next question on you mentioned, with the new delivery license that was created, there was a $3,000 in product per max delivery, or is it like, could they make a delivery and then return, replenish for another delivery or another order?
Yes, so while they're out delivering, they can't have any more than $3,000 worth of cannabis goods, the retail value. But they could go back and replenish.
Okay, thank you. And then for Mr. Parrott, you mentioned that you created some new additional license types.
Yes.
That were not specifically noted in the initial licensing or the regulations, or?
It was just in reference to the processor license, so that wasn't clearly specified in statute, and so the regulations did create a processor license. That was also in the proposed in the medicinal regulations earlier in the year.
Okay, and so the question I had was, and I don't know if there's been any contemplation to it, it may deal to some of the things that the public may inquire about. Has there been any discussions about the possibility of a co-op license that would allow the small farmers who may not have the capacity in and of themselves to comply with all of the regulatory structures that we want, to be able to come together with one license type and have a business that has multiple cultivators? Has there been any discussion or thought in that?
I know there has been, but I don't have any additional information for you today, but I'll make a note of that.
Awesome, I appreciate it. And then I think my last question was related to the extraction process, and particularly volatile extraction. We use closed loop. I spent a lot of time visiting a lot of closed loop systems around the country. Having come out of a chemical industry, I may not see closed loop the same way some of the products have been marketed as closed loop. So how do we see O-rings and quick disconnects when we define our closed loop system in California as being a process that can be used to extract using volatile products?
I'm sorry, can you repeat the last part of the question?
So there is obviously a requirement for all extraction, whether it be CO2 or volatile extraction, to use a closed loop system.
Right.
But marketed, there are a lot of companies out there that are marketing extraction equipment that I wouldn't normally define as closed loop, considering there are quick disconnects and O-rings used that can fail. Do we define the process, or what actually closed loop is, so that way these operators can make sure that the equipment that they have meet the standards that we're looking at?
Yes, so if you look in our regulations, there is more specificity about the certification process that the closed loop systems have to go through, and all those sites also have to be inspected and authorized by local fire.
Very good, I appreciate that very much. Thank you. Thank you for your answers.
Hi, I have a few questions. For the micro business license, a company must engage in 3 of the 4 activities. The cultivation is limited to 10,000 square feet. Are there any limits placed on the manufacturing, distribution, or retail pieces of that license?
No,
Okay.
but you
Which
will,
is type 6.
which is the type 6, yes, thank you.
Okay. And then,
Just to let you know, the license fee is scaled for the micro business based on how much the level of cannabis activity they're conducting.
okay. And then I'm interested in the testing, and this is probably a question for all of you. So I understand that you have the ISO 17025 in place, but that really isn't specific to that doesn't standardize any of the analytical procedures that each testing lab puts in place. So how are you going to standardize testing between labs as far as the standards that they use for THC and CBD and other cannabinoids, and also the SOPs that they have to put in place for their specific equipment?
I get the lab questions. So our scientists are going to be evaluating because there isn't any testing methodologies developed yet but they're going to look at before we even issue a license, they're going to have to submit all their testing methodologies, their standard operating procedure. So that we're going to do a strict evaluation before issuing that license, and then once those licenses are issued, we're going to go back in and do audits. We're going to have to contract. We're contracting with a lab to do those. They're going to be required to have a duplicate sample so we can compare results with another lab. And all of that is probably, we know there's a lot of testing requirements, and that's why you're going to see that phased in testing. We've done a lot of outreach to the testing laboratories to determine what they could test on day one. So we're going to be working with them over this next year to make sure we get them in compliance, that they're standardizing their testing methods. So I think there's going to be a lot of education from the bureaus, from our scientists with those licensees.
Well, there has to be, in the end, there has to be a objective party that sets the testing standards, right? That can't be set by the industry itself because they're all going to put in place different testing standards, right?
Yes.
And then how are you going to handle the edibles testing? Because dissolving, so just practically speaking, dissolving, a gummy bear or something that's, or some kind of edible, and then getting the THC content out of that mixture can be very challenging. So do you have any guidelines that will help labs figure out how they can actually accurately test these edibles?
We don't have anything specific in the regs regarding how to test a specific product, but I would have to refer to our scientists to give you a more in-depth answer of how we will go about that when we're out there working with the laboratories.
Okay, and so products are going to be pulled from the distributor for testing. Is that right? Products are going to be pulled from the distributor for testing?
So the laboratory employee is going to have to go to the distributor, and then they're going to, at the distributor's premises, pull the random representative samples from the product batches or harvest batch.
And so the products, by the time they get to the distributor, are fully packaged. So who incurs the cost of providing the testing batches, the distributor or the manufacturer? And then who in the end is held accountable if one of these products doesn't meet the requirements? Is it the distributor or the manufacturer?
Well, before the product can move forward to the retail, the distributor is responsible for making sure that the certificate analysis, it's passed all the required testing, that the labeling is correct, the packaging is correct. So it will not move to the retailer unless that's been checked by the distributor. So ultimately for that part of it, this distributor is going to be that quality control agent.
So legally, the distributor is held accountable for the products that the manufacturer sells to the distributor?
Well, first it's going to go, once the manufacturer gets it to the distributor, then the distributor arranges for the testing. If it were to go on, if something was wrong with the product and the distributor sent something to the retailer that didn't pass testing, then the distributor would be responsible for it. But at the point that it doesn't pass testing, then it could go back to the manufacturer and be remediated if that is one option. So I think it depends on the circumstances on who is responsible for the product, but obviously the manufacturer is responsible for their product. The distributor is responsible for making sure before that product has passed all the testing and all the product integrity, labeling, packaging before it's moved on to the retailer.
Right, and so who incurs the cost of, so you can imagine a distributor buys a certain amount from a manufacturer, holds it at their distribution center while it's being tested. They have to give up a certain amount of that every batch that they buy for testing. Does the distributor incur the cost?
The state doesn't get involved with who incurs the cost. That is done through whatever is determined between the licensees through their contracts.
So ultimately, it's the distributor then who's held accountable for any products making it to the retailer that don't meet testing standards.
Yes.
Sounds like, okay. And then for, this is a question for you. When you say good manufacturing practices, are you defining those according to like ICH Annex 7?
Yes, so there's extensive requirements in the regulation packet that cover all the good manufacturing practices, and these are modeled after the Food and Drug Administration for food and drug manufacturing.
Okay. And then are you defining good agricultural practices?
We don't have that defined in our regulations, but we do have requirements for cultivation plan and practices on the cultivation site specified in our regulations. But we don't call out anything that's specifically good cultivation practices as a definition.
Okay. And then how are you enforcing the track and trace system? Are you enforcing it from seed to sale or just to the manufacturer?
It's from seed to sale.
So how are you enforcing that then across the entire supply chain when you have different companies with, cultivation licenses, manufacturing licenses, distribution licenses, and then retail?
Right. So that's a very good question. I think as Lori mentioned at the beginning of the presentation, all three of the licensing agencies have been working collaboratively over these past couple years. So all of our regulations for each industry that we're regulating have track and trace requirements within the regulations. So the Bureau has track and trace requirements for their licensees, same with public health and same with CDFA. So it spells it out in the regulations what each licensee is required to do to comply with the track and trace requirements.
Okay, so inventory control.
Yes.
At each step. Basically.
That's all. It's all spelled out in the regulations
Okay.
of what they're required to do, time frames that they have in order to enter information in the track and trace system, things that need to be done before a product can move forward onto the next licensee.
Okay, and then just a last question for you about the product quality for manufactured products, especially edibles. Do you envision any stability requirements or expiration dates for, baked goods or anything?
Yes.
Yeah.
I didn't go through every detail of the regulations because there is extensive requirements. One of them is use by date or sale by date, and those have to be on the label as well.
And are the manufacturers required to provide data to support that expiration date?
What they're supposed to provide to us are their good manufacturing practices, and then when we do our inspection, we are reviewing their processes and evaluating all their critical controls, all their product recipe and everything. So we will be able to assess if they are using good dates or not.
Okay. And so I think you're addressing the recall. So let's imagine that something is found at a retailer that has gone bad. Through your track and trace system, then the manufacturer has a way to figure out at which retail locations that batch has been distributed to,
Right.
so that they can, in fact, enforce a recall of a bad
Correctly.
batch. Okay.
Yeah, so each label of a manufactured product also needs to carry the unique identifier from the track and trace system.
Right.
So if we discover that there's a problem with one product, the system can easily track that to the batch and then do the forward and backwards tracking.
Mm-hmm.
And in the system, we can actually then put stops of any of other batches that if they haven't moved to retail, the system can lock those batches down and then the product will not move to retail.
Okay. And then just one more question for Lori. With the testing, are you going to employ, third-party, private testing companies to spot check the testing labs?
So we will have in-house people that'll do the enforcement, research scientists and environmental scientists, and then we'll also have a third-party lab that we will be working with.
Yeah, okay, thank you.
I think I've gotten in over my head here. I just have a few civil rights types questions. Not so much as what was in the medical marijuana legislation, but in Prop 64. And as I'm sitting here, I'm wondering, listening to the three of you, with the fees and so forth, are we going to have a product that's going to be affordable that will eliminate the underground market, which is one of the reasons I have interest in being here. And then I think I probably glazed over with these regulations because I didn't see anything in there that addressed ensuring that those who have been somewhat damaged would have an opportunity to participate. Now, maybe it's in the language somewhere or it's in the process that I couldn't find it, but I'm particularly interested in that. Those two questions first, and then maybe my third question will be irrelevant once I just tell me, is this product going to be affordable? Is it going to really eliminate the underground market that we've had? Will there still be people selling pot on the streets because we priced the product so high through the various value-added fees as you go along the way that folks will still want to go and get it cheaply someplace else, especially now since you can grow 3 or 4 plants at home. And then the follow-up question to that, is there opportunity for small businesses and others to, is it spelled out that there's a way for them to get in and do business with the state, with the three of you? I know it's a 3-part question for 3 people, so.
I'll start. So for all of us, our licensing fees have to just cover the administration of our program. So what we've done is the Bureau's worked with economists to come up with scaled licensing fees. So it is based on the activity you're doing and how much cannabis you're handling. And so we can't take any more than what it's going to cost to administer our program. So unfortunately, there's taxes and there's other fees at the local level that we don't have control of at the state, but we are hoping that we can minimize we want to get people in the legal market, so we minimize the black market, but I think we all recognize that's going to take some time. As for more of like an equity program, the Bureau has we've looking at scaling our fees and what it costs to get into business, because I do think that's very important. And if you look at some of our license types, there was a big, what you saw a lot when we did our public comments for the draft medical regs was bringing in the non-storefront delivery only retailer, and then that was reflected in SB 94 that was added. So we've really tried to make the barriers of entry to get into some of these license types where they can they just don't have to have a lot of capital up front. They could do a delivery only. That was the thought behind the distributor transport license, because a lot of people, they can't be a full-blown distributor, so they could just do transportation. So you're going to see some of that in our regs. They're not a specific section, but I think we'd all agree I think there's more work to be done on our regulations, and I think we're all looking to move forward with this advisory committee on that.
Mr. Sweeney? I'd like to add to that our proposal for a placeholder shared manufacturing facilities license type, which we don't have all of the requirements in this emergency package, but that is specifically to address manufacturers that want to have entry into this business, but don't really have the capital to be able to invest into some of the equipment that is needed. And so that will provide them an ability to be able to share a facility.
Thank you.
Mr. Sweeney?
Yes, thank you. I
micro businesses, temporary cannabis events, and testing laboratories. When I look under there, I see a page where there is a very vague, it says, in addition, a licensee may donate cannabis goods and use of equipment in compliance with any compassionate use, comma, equality, or other similar program administered by a local jurisdiction. That's very, very vague. And I guess I'm asking the question of, is there an intent to make a declaratory statement that it is a goal, a measurable goal, to ensure that there is equity? In other words, we're responding now to moving rapidly. We're responding now to the legislative mandate. And so I'm asking, is there going to be, or is it part of our job to ensure that there is a more declaratory statement that's less vague, less ambiguous, and supportive of the equity principles that some of us would like to see?
So that specific portion in the regs has to do, we got a tremendous amount of public comment when we issued our draft medical regs that it was going to be too costly for especially very sick patients to access medical products. And in our draft medical regulations, we did not allow free cannabis goods to be given away. And so there was a lot of concern that people that are very sick would not be able to afford their medicine. So that is in direct relation to that we would allow a retailer to give medical cannabis to a patient or a caregiver as long as they had their medical marijuana card. And then we added that section because we know there are some cities out there, jurisdictions, that do have other compassionate use programs for patients that are sick. And so because there's so many jurisdictions across the state, we don't know which program that is, but we would honor what the local jurisdiction had put into place for something on that level. So that's a direct relationship to getting free cannabis products to patients who are in need of it and can't afford it.
Well, I guess there's the other part, and that is, as a state agency, is it your opinion that there is a compelling need for a more bold, inclusive equity piece within the context of these regulations or proposed regulations?
So as I said earlier, I do believe that that's one of the reasons we have this committee to guide us down the way, and I do think we can make improvements to our I think there's always room for improvements, and I think those are greater discussions, and not just with us, with the other state agencies, and of course above me too. So,
Ms. Todd?
Thanks. This actually, I think, follows up on the previous two comments and about how we make those improvements and whether, obviously I haven't read the regulations yet, but if it's in there or if there's a plan for data collection on how the temporary regulations are being implemented. Like, are we going to know who applies for licenses, why people were rejected, what barriers existed, who got the licenses, which people are getting which category of license, so that we're able to, when we craft the permanent regulations, to make adjustments that address the issues of the barriers to people coming in and some of the equity issues that are obviously incredibly important. So Are we going to collect that data, and is it going to be available? And then the second question, which I think is a harder one, but one for us to think about, is that data collection piece or monitoring of what's happening on the local level as well, because there will be a level of, by the time folks get to the state to apply, they're going to have needed the local approval, and what's happening on the local level that's going to work to exclude groups of people who might be able to come in under what the state has designed and some of the categories that you mentioned. And is there a way to at least be collecting that data as part of our committee or as part of the state agencies to address those issues, which I think are part of the mandate of the initiative and the state law, but may act as a real barrier before applicants even get to applying for the state license?
So we will be collecting data at the state level on how many licenses are issued, what types of license, where they're issued, who we're denying. So we will have that. A lot of that is going to be tracked on our online licensing system. You know, however, I'm sure there could be more that we're tracking. So any ideas that you have, that would be helpful to tell us. So we'll make sure we're tracking that in the beginning. But yes, I think, you know, we need more information. We don't know what we don't know right now when we go to implementation. So I think that information is going to be very valuable for us as we go through the public comment period for these regulations. So I think we'll be making better decisions because we'll have more information. As for the local level, we do a tremendous amount of outreach with the local level, with the locals, because they're our partner in this. They need to know what we're doing, and we need to know what they're doing. So I think it would be helpful if we're sharing that data that we collect with them, and also we are doing the same. So we're working extensively with the League of Cities and the California State Association of Counties and the rural counties, and making sure we're all collecting the right data moving forward.
Dr. Cermak?
If a retailer has a product that is attractive to children or that resembles non-cannabis products such as a candy bar, can that be sold during the transition period?
Yes, at the retail, yes.
Mr. Woolsey?
Thank you. I have two questions. Hopefully they're quick. During the testing lab conversation a few minutes ago, Laura, you mentioned that you'll have access to a third-party tester, and I just wanted to clarify that's for the state use if you need to test something, your enforcement arm, and will that be available to local governments as well?
Yes, that would be for the state. We haven't explored having it available for the local level, but it's something we can certainly discuss.
Thank you. And the other question is with the A and the M sale distinction at the retailer, will that, if it's an adult use sale or medicinal sale, will that be determined at the point of sale, or do they need to have a separate room or something built up for a medicinal versus adult use?
That will be determined at point of sale, but they could be on the same footprint, but they do have to be the same ownership structure, so you couldn't have different owners in the same area.
Great, thank you.
Mr. Stevenson?
Thank you. I have, I'd say, a couple of questions that pertain to labeling, additional question for cultivation, and one for micro. So I'll start with the labeling. How will the state mitigate issues of products not having the correct dosage, either mislabeled with a higher THC count or a lesser THC count? Question. The other question is, in terms of pre-roll cigarettes, I've noticed that some of the brands carry THC ratings that are affixed to the box before packaging, and we've sent the pre-roll cigarettes to testing only to find out that they are incorrectly mislabeled. And the other was for cultivation. How many cultivation licenses will the state license at the higher level? And the micro business question is, does a micro business have a right to retail?
So for the labeling, I'll start and then I'll turn it over to Lori because I think it touches not only the manufacturer but also the distributor and the lab. The packages have to be packaged in final form and based on the recipes, and many manufacturers already do extensive internal testing, so they have a good idea what the recipes generate and they'll put that sticker on the label. If it's tested, my understanding, Lori, is that if it's tested and it's less or more than that, as the ceiling is the limits that we are including in the regulations. So as long as it stays within that ceiling, and I believe in testing there is a 10 or 15% variance, then I think it's a distributor that can put a different sticker on the product.
Yes. Am I correct on that? That's correct. Did that answer your question, or?
I think it was question 1.
Yeah, that was question 1. I guess the other question was cultivation licenses. Previously, I believe I heard that there are going to be a certain amount of licenses. Has the board determined, or the agencies determined, how many cultivation licenses at the top tiers?
There is no state restriction on numbers of, there's no restriction in our regulations for the number of state licenses that we may issue.
And then you had the micro business, they can conduct retail activities as long as they're approved for that activity at the time of licensure.
And that's locally?
On-site consumption?
No,
I'm sorry.
I guess, Ms. Ajax, I'm asking if a micro business, there are 4 activities that they can choose from. And out of the 4, they may do 3.
Yes.
And if one of those activities is retail, do they naturally, are they grandfathered with that right, or does it still have to be approved by local municipality?
So the micro business license, they will have to, whatever 3 activities they choose to, or all 4, all that activity would have to be in compliance with the local jurisdiction. So the local jurisdiction would also have to tell us that you're approved for all of those activities, whatever the 3 or 4 that you plan to do.
Thank you.
And I did want to clarify that with regard to the state cultivation licenses, there is a limit on the type medium licenses that I had mentioned earlier in my presentation, that in the regulations is limited to 1 medium cultivation license, either type A or M per licensee.
Mr. Wu?
Thank you. I'm going to have a couple questions. I'll probably just ask them one by one so you guys don't have to track them. First, just to clarify, did you say that temporary licenses and applications will have no fees associated with it? Did I mishear that?
No, that's correct.
Okay. A lot of...
That's supposed to make everybody happy.
Yeah, I was surprised. Very surprised.
And sorry, Mr. Wu, please speak into the mic for all the other speakers as well.
Okay, I'm sorry.
Thank you.
I was very surprised that it is free in California. So, Prop 64 talked about, protecting children and child-resistant requirements, or, actually child-proof requirements. Some of the slides here mention child-resistant, the temporary rules. When I did a quick scan of it, I did not see anything, or I didn't see much regarding child-resistant. In other states, Colorado, Oregon, they typically reference Title 16 CFR 1700, which is just a federal standard that simplifies the ambiguity of child resistance. If we don't tie it to something other than a subjective nature, I think you guys are going to have a tough time, battling with interests.
I can answer that question. Okay. It is tied in our regulations.
Okay.
To those standards.
But is it in these temporary rules? Is it cited in there, or am I looking at the wrong?
The child-resistant requirement is the same for temporary versus permanent. It's just that if your primary package is not child-resistant for the transition period, we're allowing a secondary package as long as that one is child-resistant. Okay. So all products will be child-resistant on January 1.
And that's tied to Title 16, CFR 1700?
Yes, it is.
Okay, thank you. In terms of, temporary cannabis event sales, so it says it has the same application, basically you have to follow the same rules as a retail, and that includes exit packaging. So the intent is at a event where people are, say, purchasing cannabis, then if they buy a small package, that everyone still has to put everything into a larger exit bag?
Yes.
Okay. I think going back on Ms. Jacobson's conversation, I think having a distributor kind of, the ambiguity of the distributor has to test, and kind of make sure that product is safe. But if product is going from, say, a grower to a distributor without any testing, so are you guys leaving it to those two parties to kind of figure out who's responsible and just, okay, all right, clear enough. Last point is attractive to children. Who makes the determination of that? I think I've spoken about this before. In Oregon, they came into the same issue, or they avoided the issue actually, because we brought it up, which was attractive to children is still a fairly subjective term, and Oregon went through a label pre-approval process. And the hope is that to save you guys a lot of time, how do you plan to avoid this debate over what's attractive to children or not?
That's an interesting question. It's one that we definitely have struggled ourselves with. I think we do have to apply some subjectivity to it, and when we do the inspections and the enforcement, we try to outline as much as we could in this regulation package. And if the committee has any ideas or any other suggestions that we could consider for our permanent package, we definitely welcome that. I think for the state, the size of the state of California, doing a pre-approval, if you think our licensing fees are expensive now, those definitely will drive up the licensing fees because there's so many products, so many manufacturers, there will be so many packages and labels. So we try to kind of weigh all that in when we made our regulations. But after you have a chance to really look into all the specificity that's in regulations, because we did try to take out things like, gummy bears is one that is brought up all the time. So that's why the product cannot be in the shape of an animal and those things. So it's the best we could do at this point. But if you guys have any ideas or suggestions, we definitely welcome those.
Okay, and I'm sorry, I'll leave it there for now. Thank you.
And Mr. Sweeney, I know you have an additional question. I'd like to see if there's other questions or comments. Mr. Bulbullion?
I had a couple of questions. On the FDA CGMP guidelines, does that apply to the facility or just the practices of the business for manufacturing?
To both.
So the facilities would have to be FDA GMP certified?
I'm sorry, say that again?
The facility that the manufacturing operations are being conducted at would have to be FDA CGMP certified?
No.
So it's the practices?
Just the practices, and we lay out all of the practices in the regulations. So we will do the inspections. It will be public health doing the inspections.
On the distance requirements, some local municipalities take out distance requirements. If they take it out, for instance, LA is looking at no distances for certain business categories. Would the state still come in at 600, or would it go with the local?
Yeah, we would want the applicant or the local jurisdiction to provide us that authorization that they could be less than that.
Okay, so they need prior approval from the state before they can go on with anything less than 600?
No, once the local jurisdiction is approved, once we make sure they're in compliance, they don't have to go to the state first. When they come to the state, if they're less than 600, we would want to just get verification from the local jurisdiction.
Okay, so as long as they're in line with local?
Yeah, most likely there'll be something in an ordinance or something that we can look at.
Okay. On the micro businesses, as it relates to distribution and manufacturing, let me put it this way. On the micro businesses, with the exception of cultivation, are there any restrictions on the distribution sector or the manufacturing sector that will prevent them from functioning any differently than a standalone distributor or a standalone manufacturer?
There is a restriction on manufacturer. You cannot be a micro business and do volatile solvent extraction. That's the only restriction for micro businesses.
Yeah, they could be a full distributor or retailer. Is that what you're asking?
No, yeah, that's exactly.
But they'd still have to do 3 out of the 4 activities.
Okay, so if somebody gets a micro business license, with the exception of the 10,000 square feet of cultivation, there's no restriction on being full-blown distributor, manufacturer, any of that. Okay. On the testing for units, is the units per packaged product, final product, or is it based on certain minimum, maximum milligram? For instance, it says 150,000 units per batch on the manufactured products. Would that apply to the final product, or is it 150,000 100 milligram units, for instance?
So all the testing that's done at that level, it's the final product or final form.
On the destruction, distributor sends it out for lab test. Well, lab comes in, takes the product, tests it, and it fails. At what point is the decision made where the product has to be destroyed? And when it is destroyed, whose responsibility is that? Is it the distributor that ends up destroying it, providing information to the state, or is it kicked back to the original producer and they're responsible for the destruction and sign off on it?
Depending on where it is in the process, I believe it's going to be the distributor for the most part if it hasn't passed testing. It depends where it is in the supply chain.
On the owner disclosures, the way owner is defined, any person with aggregate of 20% or more, individual who participates in the direction, control, the management of the business, does that apply to consulting and management companies that are not necessarily the equity interest holders in the license?
I think we're going to look at all of those things on a case-by-case basis. It would be very difficult to just make those determinations without any additional information.
One last question. On the labs, as far as the testing, would the lab be handling their own transport, or would they have to contract with the third-party carrier service?
No, they can handle their own transport for only samples, for no other purpose.
Actually, I had one more question. Sorry. On the shared space license, and I know it's still to be determined and developed, usually the liability and compliance issues stay with the license holder. In this case, if you've got a license holder that has the license for the facility and you have individual companies coming in under that umbrella and operating, where does the liability stop? Does it still stay with the license holder, or is it passed on to the individual company that uses the facility to produce?
So those are the areas that we're currently working on in developing our regulations. But that is one of the issues that a shared facility does bring into account sometimes, depending on what the issue is of the contamination. If when we do an inspection, if we can't pinpoint it to a specific product, then if all the processes are possibly contaminated, it could have the unintended consequence that all product will be impacted. But we're looking at those regulations right now, and once we have the details completed and finished, we will issue another emergency package for them.
And it's fair to assume that the product, once it is manufactured, regardless if it's the license holder or the entity that came in and produced it, the product can't leave the facility, correct?
Yeah, then the product has to follow the same process as everything else. A manufacturer has to, transporter has to move it, or that particular business has to also get a transporter license from the Bureau. Exactly the same. It has to be track and trace. All those requirements will also follow.
Thank you.
Great. And I just want to check our speaker list amongst our committee members. I have Ms. Nevedal, Mr. Nachita, Mr. Ron, Mr. Sweeney. Are there others? Okay, great. Ms. Nevedal.
All right, thank you. I have a couple of questions. First of all, I was curious about the cultivation and the Type 3 license, and I believe you said that that Type 3 license would have to choose between an A or an M type of cultivation. Is that true for all cultivation license types? Would we have to have, say, a small cultivation license that's an A, and then in order to have cultivation that's an M, would I have to have another small cultivation plot that's an M? There's no way to overlay one 10,000 square foot license that provides both A and M cannabis?
Licenses will be issued and designated as either type A or M for the specific categories that we issue. So the applicant will need to, for instance, if they're applying for a type 2, they will be applying for that type 2 as either A or M. There is no license that is a combination A and M license.
Can you layer both an A and an M on the same 10,000 square foot plot or type 2 plot?
If you could secure a type A and a type M and have specific designated areas for each of those licensed activities.
But it can't be the same patch of cannabis that's cultivated.
They need to be separately identified.
Okay. My other question, I have a couple of them. Another question I have is pertaining to how the testing works with a harvest batch of 50 pounds and a manufacturing batch of 150,000 units. So if I'm a cultivator and I have a harvest batch that's someplace, in the 50-pound range, how does the distributor track that? Do I need to take the entire bulk of the batch to a distributor at once for quality assurance, or is that going to be managed through track and trace? If I can only, as a cultivator, say, move increments of 10 pounds at a time into the marketplace, do I have to then test every 10 pounds, or do I have a way to work with a distributor or multiple distributors to show that I've tested what's required for the entire 50 pounds, so when I go from one distributor to the next, I don't have to test again for that batch?
So you have to identify what your harvest batch is, and that could be up to 50 pounds. So you make the determination on what that harvest batch looks like, but the entire batch has to go to the distributor, and then the testing lab agent would come out and take the representative samples back to the lab. Depending on how many that is, depends on the size of the batch.
So if the distributor, say I have a 50-pound batch, and the distributor isn't willing to handle that 50-pound batch because they aren't ready to, say, move the entirety of the 50 pounds into the marketplace to the retail, can I take the 50 pounds and they're going to move 2 of those pounds into the marketplace? Can I retrieve the rest of my material from the distributor? Or if I am a smaller producer and I'm moving product in small increments, then do I have to test every single time I go to the distributor? Because my concern is that if a distributor can move 50 pounds at a time and it brings down their cost of goods sold or goods acquired, then for small producers, they're going to bear a much more expensive cost in testing than, say, a large producer that can bring their costs down and take a whole 50-pound unit at one time and leave it with the distributor for a low cost. So I just am confused and concerned how this potentially works for a smaller producer putting smaller increments into the marketplace.
I don't know that I can completely answer your question.
Does it make sense, though?
Yes and no.
Okay.
Maybe that's part of the problem. So a smaller producer can make the determination what size of harvest batch he wants to take to the distributor. And that could be 10 pounds, 15 pounds, or up to 50. So I'm not sure what you're asking.
So if you can only take your product in 1 pound increments, you have to test every 1 pound increment. Versus if I can convince a distributor to acquire all 50 pounds of that batch at once, then I won't be testing every single pound in that unit. I will only be taking a representative sample of the 50 pounds.
Yes, but that increments, the number of samples taken in a 15-pound batch is going to be different than a smaller batch. So it's still going to be a representative sample. It's going to be more samples in a 50-pound batch is what I'm saying.
Right, but I doubt that it's going to be as many as if I took it as 1 pound increments, right? And maybe we'll table that. Food for thought. I think my last question is, I was kind of looking at these definitions for outdoor and mixed light. In the original draft regulations, outdoor cultivators were prohibited from utilizing light deprivation techniques, yet here in the new definitions, the prohibition does not exist in the definition of outdoor cultivation, but it is clearly called out as an activity allowed under mixed light. And what I mean by light deprivation is simply the activity of closing a tarp. It has nothing to do with artificial or supplemental lighting. It just has to do with pretending like the days are shorter than what they actually are to force flower. Can we get some clarity on that possibly?
I'm gonna have to get, if I can, research and get back to you on that one.
Thank you very much.
Just on your sample question, maybe this will help. So you can take up to 50 pounds to the distributor. A batch, all of the batch that's going to be the testing batch has to stay at the distributor when it goes. But the increments, it's a certain percentage, and so the same percentage of samples being taken, regardless of batch size.
So for example, if it's 5% of 50 pounds, then it would be 5% of 1 pound.
That's accurate.
Okay, thank you.
Mr. Cheetah?
Yes, thank you. First, I just want to acknowledge all of your hard work and sitting in your shoes on a micro scale in LA County. I know that it's challenging, and I think everyone on this committee would agree, and hopefully everyone in the room would agree that regardless of what they think about the regulations, that you have done it in an open and fair process. So thank you for that and for allowing us to participate in this committee. I did have a question about how you intend to work with local regulatory agencies in rolling out the regulations. On the cultivation side, do you intend to contract with agricultural commissioners to do the inspections in the field, to do plan check, that kind of thing? Weighmaster activities, same question. On the retail and manufacturing side, do you intend to work with local health officers to inspect food facilities? I know in LA County, we're sort of a bigger scale, but retail food and I believe even wholesale food is implemented through a delegated authority by statute. And I'm just wondering, have you thought about that? And if not, what is your staffing plan to make sure you have enough people in the field to make sure that things are checked appropriately, quickly, et cetera?
I'll take that one first from California Department of Food and Agriculture. As you know, we work with the county agricultural commissioners. We have a long-standing working relationship with the agricultural commissioners. We have money in our current budget change proposal for our cannabis program to conduct a pilot with several counties to do just what you said, is to provide funding for so they can assist with inspections at the county level. So we're working right now with a few counties on developing requirements for a pilot program, and then we will run that pilot over the next 2 fiscal years to be able to have more resources in the field. We also are, we have the same type of relationship with regard to what you mentioned about Waymasters as well. So we are active in the CACASA group, and we actually gave an overview at this the last CACASA meeting in Sacramento at the conference, and talked about our pilot project and gave an update as to what's going on.
So I'll answer that question from the manufacturer's perspective. We definitely intend to coordinate with the local agencies that are licensing. We are modeling our program similar to what we do with food in our department right now. And the retail food code is delegated to the local environmental health. The food processors and food manufacturing, the state currently does those inspections. So our intent at this point for manufacturers is we have requested and have received in the last governor's budget positions for the field staff. So we are opening up a handful of field offices throughout the state, and those staff, they are environmental scientists. They are going to be coordinating with the local agencies in the areas and to do the inspections. If we definitely find any issues, that's where the coordination with the locals would definitely come into place.
The Bureau will have investigator staff. We'll also have compliance monitored for the distributors, and then environmental scientists and research scientists to investigate the laboratories. We will be working with the locals when we're doing this, but we plan to have staff to go in and do inspections and audits for all of our license types. Our sworn staff will be handling some of the higher level investigations, conducting the minor decoy compliance checks at the retail level, and any other criminal activity that occurs. Something to keep in mind, our online systems will also have a way for anybody to submit a complaint to us, and that could be the local jurisdiction or the public or anybody that wants to. And so we'll be tracking those complaints where they're happening, and happy to coordinate with the locals on that.
And if I could also just add one more point to touch on what Lori said, for CDFA, we will have a compliance and enforcement branch as well with compliance or with investigators. But it's just, the point that you made is there's not enough to reach throughout the state. So that's why we'll also be utilizing our partnership with the county agricultural commissioners to be able to partner up on that too.
Mr. Ron? Oh, did you have a question in response to this? Mr. Ron, please.
Thank you. From a local government perspective, you've got a section in here, 40169, that refers to notification of criminal acts and civil judgments. And the language here says that the licensees shall ensure that the department is notified in the event an owner or licensee is convicted of a criminal act or a civil penalty. And you're putting the onus on the licensee itself, not some other mechanism. And so my concern is, what's the incentive for a licensee to notify the department that they've committed a criminal act and ultimately result in a revoked license or changed circumstance? And maybe it should be the other way around, that there's a database that's created that tracks the licensees for civil or criminal penalties against them.
So there is a requirement for our licensee to notify us, but we will also, any owner will be fingerprinted with the Department of Justice, so we will get subsequent notification from them, but we are putting the onus on them to let us know. And if they don't follow that, then there would be disciplinary action taken.
Okay, but there's no penalty specifically called out for failure to notify within this. For the Bureau, we have our enforcement section at the end of our regulations, and we have disciplinary guidelines that lays out most of the violations and the penalty, and then then we have the ability, if it's not there, we can still take disciplinary action. Okay, I'd just like to see a tightening up, I guess, of that language, because if it's left up to the licensee, again, I'm not sure what the incentive is for them to contact the department that they or an owner or participant in their business is guilty of a criminal or civil act. And then following that a little bit farther, it's that information probably needs to get back to the local government entity where that business resides, so that they're aware of what's happened with that business. And then the last part of that section is talking about ensuring, again, that the onus is on the licensee to notify the department if a local government license has been revoked. And again, I think hopefully our relationship with local government and the state improves along this process, so that there's a mechanism where local government will simply notify the department that a license has been revoked, rather again than waiting on the licensee to provide that information on their own behalf. So following a little bit further down that line of thought, when we're talking about changes in license operations and so forth, again, anytime after issuance of a license, prior to submission, blah, 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 request change to manufacturing or others through the state, and the department can oversee that. But again, the local government has sort of an idea of what is happening at that facility. And if they're applying at the state level for a change in, say, a manufacturing process, to make sure that that information is being translated back to local government as well.
Okay.
Thanks.
Mr. Sweeney, thank you for your patience.
No problem. You know, I remember when the department, there was only one person. And obviously, the numbers are expanding as well. They should, given the immense responsibility. And I think Joe was correct in thanking you and your staff for doing an outstanding job. Part of my job, I think, is to track and trace diversity. And so I guess my question would be, how many staff do you have at this time? And how diverse is that staff in terms of both gender, race? How does it look? Is it as diverse as our state? Or could you, and you don't have to answer this right now, but what I would say is if you could make that data available to all the Cannabis Advisory Committee after you have gone over that?
I'm looking to my chief counsel over there, whether I'm allowed to provide that information.
Right, I think there's been some different conversations about data and what data will be kept. We're certainly going to take data to talk about our program and to run our program. In terms of what data can be collected and shared, there's some very specific rules. So we will be looking at that and determining what data we can collect and require and share, and what data we can collect on a voluntary basis and share. So there'll be more to come on that, and we'll have to dig into the specific requirements of what people are looking for.
Okay, well, there's one more data piece. What is the, what budget are we working with? Can we talk about that?
I'm sorry, budget for the data or?
No.
Okay.
Overall, the overall budget for the Bureau of Cannabis Control and so forth. What is the overall budget we're working with?
Well, that changes right now because our program hasn't been fully established. So we did get approval for fiscal year 17-18. Off the top of my head, I don't have the exact budget, but a lot of what you're going to see as we begin accepting licensing fees is we have to begin to pay the general fund loan that we've all been borrowing off of. And so I think once that's paid off, we'll have a better sense of what our budget is going to be on an ongoing basis. Right now, it's changing based on the needs. It was different when I first started because we were only regulating medicinal cannabis. Then it changed again when that expanded to adult use cannabis. So, and it's still changing. So more to come.
I think we're going to have to redirect the conversation to regulations again, so let's make sure we stay on topic.
Well, let me just say this. I appreciate the work you're doing. A budget question is kind of a taxpayer question as well. And I'm not going to press. I'm going to be smart enough not to press right now, but that is something that I think the public has a right to know.
Yeah, and our budget is online with the Department of Finance, so you could see our current budget for this fiscal year. And the goal is once we pay off our general fund loan, our licensing fees will completely support our programs.
Thank you.
Ms. Huffman.
I might have some help at the table on this one, but in Prop 64, we went through and tried to eliminate as many barriers as we could that would prevent access from the constituent base that we cared about. And one of the things that we removed was the bond requirement. And I talked to the Board of Equalization about bonding and was told that we don't use bonds that much anymore. Then I just glanced down at this beautiful piece of paper and I see that there's a $5,000 surety bond. And I saw that in the language that was proposed from the governor's office, and we flagged it and went over and met with the governor's chief of staff and pointed out that we thought that language was a barrier. And we were sure that nothing would show up in these regs that were not included in Prop 64 when you combine the two programs. So I'm curious about that one, but I do have one quick question. You want to answer this before I ask this?
Oh, yeah, that
Go
might
ahead.
be helpful. And Tamra, correct me if I'm wrong, I believe it is in the MAU CRSA that the licensees have to post a bond for cannabis destruction.
That's in
That
the
is-
medical marijuana.
Yeah, but in the new statute, that is a requirement.
I don't think it was in Prop 64. We eliminated
I
it.
believe it was SB 94. I believe it got added in the trailer
Yeah.
bill.
And we asked it to be taken out because it wasn't in Prop 64, but we'll go back and look. I went down to San Joaquin and saw a hemp farm, and I wonder who's regulating that. I know it was leveled. But do we have any regulations? Who's handling?
So there is, at the California Department of Food and Agriculture, there is a hemp advisory board. They had an advisory board meeting last month, and they are working right now on the regulations regarding hemp.
Ms. Jacobson. This is another question from Miriam, but I think you answered it. So you're not going to, for every application for a manufacturing license, are you going to inspect the facility before you issue the license?
Not at this point.
Okay.
We don't have the staff at this point, and the first thing that we're going to issue is temporary licenses to meet the deadline of January 1st. That could be a consideration once the program is stabilized, maybe down the road.
Right, that makes sense. Thanks.
Mr. Wu.
Hi. Miriam, not to beat a dead horse, but when you say that child-resistant references Title 16 CFR 1700, is it specifically in this document, or is it related in a different document?
No, not that document. It is in another package for the manufacturers. Do you
Got
have
it.
all three packages?
I have.
It's in that one.
Okay, I'm sorry. I just caution that because I believe a shortcut that a lot of our customers are likely to do is review the biggest one, right?
I
And
know.
then just because I'll be having to point them to the other so I just want to be clear.
You
clear
know
on that.
how verbose we are at the state.
Okay, got it. You write opaque packaging, parentheses, edibles on this. So is that an indication that other product lines will not require?
It's the requirement in statute, I believe, for just edibles that have to be opaque.
The other point here, I'm just going off the slide, is cannot resemble traditional food packaging.
Right.
Can you clarify on that?
Right, so that is in response to what we have seen in some products that are made to look like Oreos or some other candy that's available. And that requirement is to prevent that. So in other words, copying the color and the packaging and just changing a couple of words, and it looks like it's a traditional food product.
Okay, so that's tied more to the marketing of it rather than the actual physical packaging, if you will. We're
No,
not
it's tied to the packaging and labeling.
Okay, so just to clarify then, if a 2-ounce baby food jar is traditional food pack, you're not talking about that form factor. We're talking about with a label in conjunction. Right, because I just want to make sure we don't eliminate 90% of all the products that people are already using to package cannabis, whether it's a jar or a barrier bag that people put beef jerky in. When you say traditional food packaging, I'm just trying to really
Right,
hammer
yeah,
down.
it's not those examples.
Okay,
no.
okay, just to be clear.
Yeah,
Thank you.
and if any applicant has a question, they can always call us, and we'll definitely answer these questions on a case-by-case basis.
Okay. So when it comes to kind of events, right, you're prohibiting alcohol consumption as well as tobacco consumption, so
That's in statute.
that's in statute, okay. Okay. Do you have any idea of kind of how many applicants you expect kind of early on? And this really just goes more towards your servers, if you're doing online applications, and are your servers going to be capable of kind of initially taking all those applications, or are people going to be frustrated with crash servers?
We have done performance testing to make sure that they are capable of handling the traffic that's coming in.
Right. And last question, just on your requirement of tamper evident, you kind of specify you having a fixed seal. Is that indicating it has to be a sticker, if you will, a fixed seal? I'm just technical.
I can see that. No, tamper evident means just like any product you purchase right now, is when you open it and nobody else has opened it.
Okay. So it could be done in a variety of ways. It does not have
Yes.
to be. Okay.
Yeah.
Great. Thank you.
Great. Any last questions, comments from our committee?
2 questions. On the bookkeeping for cultivation, let's say it's a single company, they have 2-3 locations, 5,000 square feet each location. Are they allowed to combine the data from all locations and have one reporting as a company, or does the bookkeeping and the recording go with the license, not the company?
I don't know that one offhand, but I need to look at that, and I'll let you know.
And the last question I have is on the manufacturing side, and again, it's on testing and testing cost. When you do a run as a manufacturer, you run X amount of SKUs. Are you allowed to combine the SKUs to make it? Here's where my question is going with. Even with the sliding scale as far as testing goes, the less you run, the less your testing costs are going to be. But there is always that minimum where unless you're running that minimum, it just doesn't make financial sense to run it because of the testing components. Would you be able to combine multiple runs together into one batch and then have that batch tested?
So you're asking for testing how you aggregate the batches?
Would you be able to aggregate the batches, the different runs, for one test?
Tamra, I'm not sure. Do you know that?
It depends. It must meet the requirement per batch for the same type of genealogy, and then it also has to stay with the same batch. So it would depend if how you're doing it, whether or not they can meet those requirements for the batch.
So if it's the same material, same oil, same product, final product?
You'd have to look at what your process is and the definition of batch and make sure that it falls within that definition.
Thank you.
Great. Any final questions, comments from the committee?
Good work.
May I ask one more question, please? Kristen?
Sorry, Ms. Nevedal.
Sorry. Just going back to the event permits, so will the, say, fairgrounds be able to offer alcohol? They wouldn't necessarily be the ones pulling the special event permit. So if I pull in a special event permit, can the fairground or the location still do alcohol sales if they allow for a cannabis event at that location?
It would first it would have to be approved, one, by the Alcoholic Beverage Control, the fairgrounds, but it have to be separate from the event, so they couldn't.
So as long as it's not the event organizer or the event permit holder, there can be another entity.
And they'd have to be, the premises would have to be separated.
So you could literally section off a cannabis area versus a alcohol area?
In theory, yes, if that got all the necessary approvals.
Okay, thank you.
Okay. Thank you, Lori, Richard, Mirren. Before we go in and open for public comment in response to agenda item 10B, just wanted to share a few reminders with our attendees today. One, I know there's been a lot of requests for the PowerPoint shown by the 3 licensing entities. We are working with our folks now back at the department to post those as soon as possible, and we'll message that out as soon as that's done. Thank you so much, committee members, hopefully, and I am assuming so, that you answered many of the questions of our stakeholders and those watching through live webcast. As there's a lot of interest, I know, in folks probably providing public comment, and then us getting to about the 4 o'clock hour, we're gonna, for right now, limit comment to about 1.5 minutes. If everyone has the opportunity to go, we'll then go back around to secondary questions if you have any. And if you could start lining up on the blue X's, that would be great, and we'll have the first 3 speakers sit at the table. The timer will be in front of you, and Rebecca Nicholas, to your right, will call when the timer has expired. 10B, yes. So the presentations that you just saw before you. A couple last reminders as we get into the public comment period. Definitely please direct your public comments to our committee. They are serving in an advisory role to all 3 licensing agencies, including to the development of the regulations that you heard today, and that will be starting next year. And please note too, of course, this is not your last opportunity to ask questions and engage with our committee and all of our licensing entities. We always encourage you to reach out to our various state departments directly, and we'll continue to work with everybody next year as we get into the regular rulemaking process. Great. Sorry, question before we get started? No, we're asking you if you could possibly limit your comments to approximately 90 seconds, a minute and a half. We'll have a timer. Rebecca Nicholas will be helping us coordinate. And if we get through everyone's questions in an appropriate amount of time, we'll go back around if there's more comments from our attendees.
Okay, so I'm going to be running the timer. It's just right here in front of you. It'll ding when it's up. And just a reminder that we're really hoping that you can turn your questions into comments because we want to hear from you today. Once we break, if you have individual questions, we have staff and members of the committee who's obviously available to chat with you one-on-one. So we're going to go, if we could start right, left. All right, go ahead.
Testing. Good afternoon, committee. My name is Charles Fraser. I'm the Chief Operating Officer for Minorities for Medical Marijuana. And I just want to make some comments about in regards to Ms. Huffman, and it was addressed with the equity of Mr. Sweeney. The data shows that for over 2 decades, Black and brown residents were arrested and incarcerated for drug offenses at disparately high rates, while largely white cannabis cultivators, manufacturers, and distributors who were not operating entirely above board either flourished under changing laws designed to accommodate the burgeoning industry. That was quoted by Darlene Flynn from the city of Oakland. The Oakland City Council first brought these issues to light and has previously explored several alternative legislative proposals in 2016. The newly adopted regulations seek to address the ongoing economic inequality that results from disparities in drug arrests, as well as other racialized barriers to wealth building and business ownership by bringing innovation and an equity lens to the new cannabis business licensing process. The development of more diverse, equitable, and inclusive legislation at the state level for the medical cannabis industry will have a positive effect for the industry as a whole, as business owners and ancillary business owners consider how to take advantage of the new adult recreational use of laws in California. I do have a working document that provides a framework of existing cannabis diversity legislation aimed at creating equality, diversity, and inclusion in the industry. California's Prop 209 prevents us from doing this, so I do have other things I can share.
Thank you, Charles. Thanks. All right, next.
Hi, my name's Paul Hansberry. I have a small farm in Mendocino County. We've been making medicines for seriously ill people for a very long time. I think I'm talking about manufacturing here for a micro business out of my home. The regulations seem to be geared towards large industry, major industrial manufacturers. The security measures that are in this regulation for manufacturing, I mean, I would have to wear a laminate badge with my photograph on it to walk around my house and then sign in and sign out as I went from one room to the other because I have to comply with their security. Secondly, I noticed on the PowerPoint there was 3 different, there was ethanol, there was non-volatile and volatile solvents, or CO2 and volatile solvents. Ethanol has been used for centuries for making tinctures. the small farmer here, in an effort to carve out a niche and to do what they've been doing for generations, has to start producing some sort of value-added product in order to survive, in order to keep food on his and pay his bills. Ethanol has been used for making tinctures. All you're doing is you're soaking the cannabis in the alcohol. It's safer than it's as safe as keeping a bottle of vodka in your liquor cabinet. Further, there are UL-approved devices, distillers, that are certified for home use for using ethanol for making extractions. In Mendocino County, they have language in their ordinance for using volatile solvents in a non-volatile method.
Thank you, Paul. All right, next.
Susan Tibbin. Can you hear me? Yeah. In addition to being a liaison with Mendocino County and Sacramento, I am retired faculty of the California Academy of Sciences. I'm looking at a document talking about best practices. Small farmers are implementing best practices. They're using integrated pest management. We're stewards of the land. We have companion plants. That means that the emergency regulations are asking us to look at our whole garden and charging us, instead of for the 2,500 square feet of canopy, which is the drip line of a plant, they are charging us for over 20,000 square feet because they're including all of our best practices, our integrated pest management, our companion plants. Please don't penalize small farmers. In addition, this document talks about not cutting people out, about promoting the black market. Right now, in our northern counties, we've got stickers all over the place talking about the black market. So please include us. We have members in California Growers Association, for whom we are founding members, of the Black Farmers Association, old people who've been up there for generations, young people, third and fourth generation, who are stewards of the land, gay people, self-identified, lesbian and homosexual people. We have all kinds of people. Please don't cut us out.
Thanks so much.
Thank you.
Hello, George Bianchini, again. Since I only have 90 seconds here. The Hemp Board needs some of the funds that was procured under Prop 64. It's only fair, since it's been split off, that they get some funds to operate. I offered them a loan. They said it wasn't legal, but they're operating out of their own pockets. They're taking their monies out of their own pockets to do everything that they're doing right now. It's not right. I do have a question on the regulations of the APC count. I saw a lot of the micro stuff in there. I saw nothing with APC. And that comes back to something similar to what this lady was just talking about here, was that the fact of the 25 farmers I currently do business with right now, I've had to give up all of the organic farmers because the testing requirements, at least done in the city of Berkeley, outlaws the methods used by organic farms. And I think that was because they had people writing regulations that don't know a bacillus from a thermungus. Y'all know what I'm talking about, right? Okay, so my question is the APC count, is it still there? That one line item would take care of that. And these are all the good bacteria that are used by the organic farmers. My time is just about up here, so I wanted to do one more thing here. The 120-day possible extension. Is it possible it can go 119 days so it's not falling on April Fool's Day? We've been fooled long enough.
Thank you, George. All right, next up.
Are testing laboratories required to analyze for the FDA requirements for content of alcohol or shape and appearance of the packaged items so that it doesn't look like that it's for children or whatever? Does that make sense?
If you could form that into a comment, that'd be great. Or else we can talk to you after this meeting. Sounds like you're concerned about packaging.
So I can't ask questions then?
Can you turn your question into a comment?
Well, no. What comment I can say, though, I guess, is that these emergency rules do not have a provision for a contingency when a testing laboratory reports results that do not meet the specification.
Thank you. Thank you so much. Anything else? Okay, thank you.
Hi, my name is Jen Price with Pacific Expeditors Consulting Services out of Santa Rosa. For the CDFA, I need some clarifications in the environmental impact report that came out earlier this week. In section 2.2.4, it says, with a few exceptions, CDFA will not restrict the total number or combination of cultivation licenses a person holds, provided the person does not exceed the total acreage cap of 1 acre established by CDFA. Until January 1, 2023, licensees will be limited to 1 medium outdoor, 1 medium indoor, or 1 medium mixed light license. I do not see anywhere in the regs that came out today anything about a 1 acre cap, and I need clarification on that afterwards if I can get that. To the BCC, looking for clarification on transportation distributor for a property or parcel that has multiple premises on it. For example, multiple cultivators with their own licenses who share a single processing license facility on the same property. Are they going to be required to have a distributor or a distributor transporter transport all of their material within their own property just because it's going between licensees? I think that's a little needs clarification. To CDPH, I just flipped through your regs twice, and I'm not seeing any detail on the actual license types. I'm seeing a lot of information, but not laying out the license types. I think there needs to be clarification on what you mean by no additive caffeine.
Thank you very much.
Hello, my name is John Webb. I'm a small cultivator in Trinity County. I would like to talk about Ms. Peck's point about the cost of testing. If you bring in 1 pound and they take 5% of your 1 pound and charge you $50 for that test, and if you bring in 50 pounds and they take 5% of that and they charge you $50 for that test, if I bring in 1 pound, I'm being charged $50. If I bring in another pound 2 weeks later, I'm being charged another $50. You see what I'm saying? So if we could clarify how the testing works. I would also like to make a suggestion that instead of allowing the distributor to do the testing, to allow the cultivator to do the testing. As a cultivator, I price my product on the THC as well as the look and how the flavors and the terps are. If I can test my product through a testing facility myself, then I can make a better suggestion to the distributor on what the price should be. Also, the distributor, by taking the product to the testing facility, he purchases it from the cultivator. He then takes it to the testing facility. He's already paid for the product. If it's a bad product and they have to destroy it, it's the distributor who carries the loss, right? He's already paid for the product. He wasn't responsible for that product. So I think that the cultivator should be responsible for the testing process before it goes to the distributor. And also, I'd like to thank everybody very much for being a part of this. This is such a great thing that's happening, and it's great.
Thank you so much. Hi.
Hi, my name is Matthew Chapin with Chapin Law. First, I would like to thank everybody who's involved in this, because this does take a lot of hard work. It does not go unappreciated. I do foresee a lot of compliance issues, at least in the first 12 months, and not for the sake of intentional compliance issues. So I would suggest to everybody involved to, at least in the first 12 months, have an increased degree of leniency, at least for first-time offenders. Thank you.
Thanks so much.
I'm trying to form this into the form of a comment instead of a question, but I am interested in doing third-party packaging, and I'd like to see a little more clarification on businesses that run vertical to the marijuana industry as far as...
Could you lean into the microphone?
yeah.
Sorry.
I'd like to see a little more clarification on businesses that run vertical to the marijuana industry. We don't handle, grow, or sell it, but if a distributor would like to drop off product for co-packaging, I'd like to see more clarification on whether I'd be a micro business or a processor. And I guess just a lot more clarification on that and what kind of licensing I'm going to need to make something like that happen.
Thanks so much.
Ray again. Comments, what about having temp workers be employed that work for the cannabis clubs The distributors, could they contract out following all of the requirements? I would also think that the Bureau might want to look at creating something like an SBA loan program to help the folks who, going to need the capital, because those guys out there are charging they want big returns. The delivery only, I'm assuming that's only for medical. Insurance coverage, that has been an issue I've read in some of the trade magazines. I would think you might want to look at the California Earthquake Authority, and that works where insurance companies take the premium and the policies are written by the state. The state invests the money. So I think that would help tremendously where, earthquakes happen here and many of the insurance companies didn't want to be in the earthquake business. They start pulling out. So the state insurance agency said, hey, let's create this California Earthquake Authority. Then that brought them in because they want that fee. So I think if we could create something like that for the cannabis industry, that could work. Also on the background check, Oakland has allowed folks who were convicted for marijuana to have a permit. So we want to hope that the state will recognize that. Thank you.
Thank you very much. All right, next up.
Hi, my name is David Edgerton. I'm with CW Analytical. We're a cannabis testing lab based out of Oakland. Earlier, there was a comment about 17025. Having just gone through my audit, I did kind of want to clarify some things for you guys. The 17025 is not written specifically for cannabis labs. Indeed, no standard is, but it is a measure of the competence of any testing facility. So it does look into things like limits of quantification and repeatability and things of that nature. So it is a fairly generic standard, but it does work pretty well internationally. In addition to that, there are no standard methods for cannabis. So each lab has had to develop their own techniques and use their own instrumentation to achieve the best repeatability that they can. That said, that's going to differ drastically depending on what analyte we're talking about. And there's a lot of analytes in there that we're being asked to test for at a trace level. It's going to have a high amount of variance. That's going to inevitably lead to a situation where one lab is going to call a product a failure and another lab might call it a pass. And I'd just like to see some better clarification on what the implications of that are and where we go from there. Also, to keep in mind that testing always has a cost, and that cost is invariably passed on to the patient. So requiring things like terpenes and the like is maybe not necessary.
Thanks, David. All right, next up.
Also, I had a thing that I prepared for everybody. I don't know if I can pass that out.
If you want to leave it here, yeah, we'll make sure to get that distributed. All right, go ahead.
Hi, my name is Justin Fischetek. I'm also a testing laboratory operator, and I would like to comment that I think we need a little more clarity on who's writing these testing regulations, how much expertise does that person actually have who's writing these regulations. I was a little disappointed that there's really no one on this committee, as far as I can tell, that is an analytical chemist who, should be advising us on this kind of stuff. I mean, we're willing to help on this issue, but so far I feel like we're writing a lot of documents that are being read mainly by lawyers and policy people who don't really have the technical knowledge to go over some of these which are technical issues. So I would just like to see a little more clarity from the Bureau about who we should be writing these comments to. I think we need to have much more detailed discussion about what's in these testing regulations, not just on the type of compounds, types of methods, all these sorts of issues. And yeah, that's just about it.
Thank you. All right, go ahead.
Hello.
Hi.
So the representative from Horizon Water and Environment had mentioned a previous environmental impact statement that was done pertaining specifically to micro businesses. And I was hoping that report or its findings could be put on the BCC website so we could publicly view it. If it's already available for public viewing, I'd very much appreciate it if someone could point me in the direction of it. And I'd also like to request just a little more clarity as far as how record keeping will be conducted in micro businesses. I understand we probably won't be using the trace system that some larger licensees will be using. So a little more clarity as to what exactly records we would be required to keep and for how long would
would be very much appreciated. Thank you.
Thank you. All right, go ahead.
Hi there. My name is Katie Maple, and I work for a firm that represents nearly every sector of the cannabis industry. Though I have a lot of really specific questions, I'll leave those to the agencies, and I'll just make a broad point. My understanding of the current regulations is that if you're either temporary licensed or licensed by the state, you can only do business with other licensed entities. And I think that that's going to be a very limiting factor into getting businesses into the regulated market. So if you're a business that has an entire supply chain and your entire supply chain isn't licensed, then you cannot do business with any of them. In their perspective, how do you compete against the illicit market if none of the people that you work with are licensed and you can't do business with them? And so my fear is that you'll see a lot of businesses that are unwilling or unable to take that jump into getting licensed because they fear that they won't be able to participate as well as those in the illicit market. So I just ask that we consider doing some kind of transition period where we either allow these businesses to continue doing some kind of operations with others as long as they're on the path to licensure, or we create some kind of incubator type of project where we're helping those who are on the path to licensure get those within their network license. So for instance, maybe distributors would be a good place to start with that. So thank you.
Thanks very much. Go ahead.
Hello, I'm Marco.
Just speak into the microphone. Thanks.
Hello, I'm Marco Trani. I've been a cannabis chemist for the last 5 years in analytical laboratories. I started in California at Steep Hill, and then I opened as lab manager the first testing lab in Nevada, DB Labs. The regulations in Nevada are very similar to the ones you guys are proposing. They're very thorough, and they take contamination testing and safety of patient health into account in a way that is undone in the California market now. One thing I've seen in the last 5 years is that business interests push labs to inflate THC values. Now, the reason I'm bringing this up is I saw in the regulations. Sorry? Lean in a little more. There, can you guys hear me?
Yeah, thank you.
One thing we've seen is the inflation of THC values a lot in California and other states with this industry. And it's usually business pressure pushing the labs to report higher and higher THC values so they can make more money at the dispensary. Now, one thing I've noticed in your proposed regulations is that instead of having the THC and terpenes that are tested by the lab be reported on the label, they need to match a label that I am assuming is proposed by the client. Then there's about a 10% tolerance. What I'm foreseeing is that the business interest will use this to be 9% over the lab results every time. And you're basically going to have a 9% markup to stay competitive in the California market. What I would recommend is some kind of system where if a certified lab gives a client a THC result, they have to use that on their label. Or, if they don't trust the lab, they can get it retested by another certified lab. But this idea of passing or failing for cannabinoids and terpenes, I think, could lead to trouble.
Thank you very much. All right, next up.
Hello, my name's Jack, and I'm going to comment on the distributor and how much that they can carry. For most categories like concentrates and salves, I think 3,000 is perfectly reasonable. But if we're talking about the herbal, like the flower, if we're talking about top grade, it's $20 a gram per pound. That's $8,960. So per pound, somebody would have to take more than 3 trips just to, a distributor would have to take more than 3 trips just to go within their $3,000 retail range. That's all for me.
Thank you very much. Next up.
Good afternoon. My name is Sean Aguilar. I'm from Fairfax, California. I'm a private banker, real estate private banker, working with investors, owners, operators, and tenants. I want to thank you for allowing me to appear here today. I had a couple questions on the rules and regulations, and just some comments, actually. Article 2 under application, Section 5007, I believe it's called Landlord Approval. I'd like to suggest you standardize number A, work with the Bureau of Real Estate, create a form from them. This has to do with getting a letter from a landlord saying that the tenant is occupying. Excuse me. I've done some work with them in the past, and I think if you can work with that division, create a document in a form that becomes standard, and then therefore that'll help simplify your process, it'll expedite it, and from a compliance and audit perspective, it'll make it much, much simpler for you. The other thing is just under B, under that same section, landlord approval. It talks there, if you will, provide the Borough a copy of title or grant deed of the property. This has to do with the landowner himself. I think you need to be a little more specific. I don't know how you provide title, but I do know how you provide a grant deed. So I'm not sure if you mean a copy of a title report that reflects the ownership interest or something along those lines, but you may want to look into that as well. And let's see here. I have one more thing. Oh, yes. On Article 3, licensing under the fees.
Thank you,
There's
Sean.
a duplicate under distributor transport only. Thank you.
Thanks. All right, go ahead.
Hi, Ray again. Just got one more comment. Being that we want to look at diversity in the industry and capture data on that, maybe in the application you can have selections for people to select, minority, African American, whatever, business person, and then they're giving us, I think, that approval to capture that data, and then we can now look at, the various business by minorities, women, African Americans, so on and so forth. So I would, hopefully you could put that in the application before it's, even rolls out. It's just one course. But, programming might don't allow that. But I think that will help tremendously when they say, hey, I want to tell you that I'm a minority. And I think that'll help capture that data that we can really, I would feel we could really use and we'll know. Thank you.
Thanks very much. All right, next up.
Charles Fraser, Infra MM, and Assistant Special Assistant to Aubrey Stone, the California Black Chamber of Commerce. One item that has not been on the agenda was the appropriations of funds for AB 1135. We feel that the language needs to be amended to ensure that diverse groups and organizations that look and speak the same language of the communities they serve and represent need to be identified in that language in terms of how those monies are appropriated. We believe that there needs to be standalone legislation as to where Prop 209 is not applicable in the cannabis space. We also would like, our organization was instrumental, and we also adopted the language for the state of Pennsylvania and Florida on diversity. So we would like the council or the Bureau to consider I do have that working format for Florida and Pennsylvania, as well as the equity program that is outlined for the city of Oakland. And to also encourage outside consultation, which is needed to ensure fairness and equality in regards to equity, diversity, discrimination, decriminalization, expungement for the purposes of equal opportunity in this cannabis space.
Thank you, Charles. And just a quick reminder that we will have the next agenda item that's on anything that's not on the agenda today. All right, next up.
Hi again, my name's John Webb. Just a couple quick things. I didn't hear anything discussed about banking or how money is going to be transferred, being that banks are FDIC insured. If they know you're a cultivator, distributor, or in retail, they will freeze your accounts. So how do we go from a distributor picking up 100 pounds at $1,000 a pound, that's $100,000 in cash? How do they make those transfers in the money? And how do we pay taxes to the Board of Equalization if we can't have a bank account being in the marijuana industry? Also, I'd like to point to Mr. Sweeney's point about the funding of the BCC. If there comes a point where they're making more money from the application fee or from the licensing fees than what they need, will we reduce the licensing fees? I would like for us to look at that at some point. Thank you.
Thanks, John.
Hi, Mark Whitlow, Marine Analytics. I want to state that stability testing, at least for medical products, should probably be instituted. We, in our testing lab, have noticed that they do expire with time. There is a diverse amount of matrices out there that people that are using, and we do not know what their effects on, particularly like THCA. If you have a THCA product where you want only a smidgen of THC in it, then stability should be mandatory. The only other thing that I need clarification on is the micro business testing process. How do we get from, does the testing lab pick up process from a micro business and then do the testing and report back to a micro business versus doing a distributor? I think that's the answer, but I don't know. Thank you. And thanks everybody for all their hard work. Bye-bye.
Thank you, Mark.
Hey, I have a little prediction for y'all. Years from now, people are going to be thanking you
and I'll tell you why. Doug Scott, I'm American Biotech Testing in Salinas. We also make medical foods for cancer, and one of the exciting developments is with our lab, other labs, the ability, technology happens from lab testing. So in the ensuing years, there's going to be some exciting progress. So thanks.
Thanks, Doug. All right, next up.
First and foremost, I would like to thank everyone here, both the advisory and those in attendance, for being a part of California history, first and foremost. Secondly, my name is Terrence Thomas. I represent Armortech Security and Investigations. So what I'm here to, I guess, say and or bring to your attention in the form of a comment is the only thing that we actually focus on is the safe access portion of all of the regulations that you're putting through. So that goes down to you receiving your tax revenue and how that will actually get to your offices. Because as we know, cannabis is an all-cash industry, and that puts a large target on the entire state, regardless of what license type there is. So I would just like to suggest we have our hands in, a lot of compliance and security planning for different counties and states. So will there be a overall, I guess I'm going in the sense of a question, but I would like there to be an overall security addendum for specific aspects of the industries and or licensing and or for organizations themselves. Because again, safe access is our biggest caveat of what we do and how we approach this industry due to its target and also prosperity of it as well. So I appreciate your time and thank you.
Thank you, Terrence. All right, last comment.
Hi, 2 points. One, the gentleman just was talking about, and that's with the fees. As cash flow gets worked out and time goes on, I would assume the extra monies go towards some sort of a fund for an equity program. Right now you have individual communities such as Oakland, San Francisco, LA, looking into seeing how they're going to do that. But from a businessman's standpoint, when you have to give half of your company away, the investors don't like you anymore. It just doesn't work. I'd like to see some sort of funds that would come from this board, whether it comes from a taxation or something else, where you can fund and have a mentoring program and actually teach people, the industry and give them a fighting chance to survive. The other thing that I wanted to discuss is on the testing. I see Lori isn't with us right now, and she's heard this from me probably too many times. But we had a licensed engineer company do a chain of custody test with 3 of the Bay Area lab dispensaries. 25% failure rate. And so I bring it up in 2 points. So when you fail on E. coli and the farmer has his product destroyed and you charge a lot of money for that, because I take it it's going to be hazardous waste, the lawyers are going to sue everybody when it was one of those 25%. When that E. coli gets through and kills somebody, the lawyers are going to sue all of us again. We have a problem with testing. Thank you.
Thanks very much.
Thank you. Seeing no more public comment, I'd like to turn it over to Secretary Podesta to close. To close agenda item 10B.
Thank you, Melanie. And I just wanted to thank everyone for being here today. I know that sentiment's been echoed already, but this has been a huge undertaking from the beginning, and I specifically want to thank Marion and Lori and Richard and your teams. So many of these days, very long days that turn into weeks and years at this point, go without a thank you or a nod of appreciation, and often end up with a whole list of more that we want from you all. So I just want to acknowledge the really hard work and great product that we've all seen today. I think we've all heard that, this is just the beginning. If you're familiar with how we regulate businesses in the state of California, regulations are always changing. There's a very formal process to do that. Stakeholders and the state are always engaged, and as industries change, regulations change, there are always endless pieces of legislation that make their way to the governor's desk for his decision that will also shape this effort as we move forward. So I think we've got a really great foundation to build on, and I'm really proud of the work that's gone into it. I've also heard a lot of really great ideas today and look forward to working with you all as we build up on this foundation. And last, I just want to acknowledge the awesome members we have here today. I sit on many boards and advisory bodies, and rarely do folks ask a single question, yet, to even think about asking so many incredibly engaging questions is really just inspiring to know that we've brought the right group of people together here today to help us move forward and make some tough decisions. There's lots of competing interests. We've got stakeholders that represent, local governments to patient advocates and everyone in between. And then we've also got our charge to protect the consumer and keep this product out of the hands of those who shouldn't have it, primarily children. And so I want to thank everyone today. It was a long day, and I really appreciate you taking the time to be here, to hearing from our folks about what we've put together for you, and I look forward to hearing from you in the future. Thank you.
Thank you, committee members and everyone for sticking with us the whole day. Thank you, Secretary. I know folks may need a bio break, so if you do, please get up and return. We understand. And we have 3 agenda items left, so thank you again, committee members. If we can stick through this, I think we can wrap up fairly shortly. Moving on to agenda item number 11. This is public comment on items not on the agenda. I know we run the meeting in a very organized manner and according to Bagley-Keene. So again, this is public comment on items not on the agenda, and we'll run it the same way we just ran public comment earlier.
I need 3.5 more.
Thank you.
All right, go right ahead.
Okay, thank you. Again, I'd like to address the Assembly Bill 1135, where the money's appropriated to programs where health, welfare, public health, so on and so forth. It was mentioned at an equity summit through one of the team members, I believe, with Ms. Lori Ajax and Dean Graffalo, where those monies would be appropriated to communities in different diverse organizations, but those are not defined in that Assembly bill. And we would like to encourage that the Bureau enforce or try to come up with creative ways to amend that language. It is very, very important because we don't want any language in that bill to be assumed or misinterpreted. So we would like to see that in ink and not just assume that those monies are going to go to organizations, to communities that look and speak like their communities. Also, the essence of we need to consider the insurance initiatives on this as well, as it pertains to commercial property as well as healthcare, how those initiatives will be addressed for the state of California. And also that we hope that the Bureau will enforce counties and municipalities to adopt all the regulations and of the state and not just cherry pick based on their own their biases and undocumented statistics.
Thanks, Charles. All right, next commenter.
Hi, my name is Ryan Reeves. Thank you all for being here. This has been an incredible experience. I'm a graduate student at Mills College studying public policy, and I've been lucky enough to be able to study emerging cannabis policy while in grad school studying policy. And I just wanted to touch on 2 things really quickly that I've been noticing as I'm pouring through municipal codes from cities and counties. Type 7 Level 2 manufacturing is incredible. Some of what extractors are able to produce is really pushing the science of cannabis production, and these are incredible products. But so many cities and counties are not going to regulate Type 7, Level 2 manufacturing. And I think at the state level, we should be encouraging cities and counties to be a little more brave with these policies and move forward and not just rely on Type 6, which has its limitations. I also would love to see an expansion on the language involving nonprofits. There are some amazing compassion programs out there that a lot of cities and counties have to take on their own. And I'm afraid that these compassion programs that get free medicine to people who need it are either going to disappear or they're not going to be encouraged.
Thanks, Ryan. All right, last commenter.
Thank you. The last topic I wanted to discuss with you today is several weeks ago in San Joaquin County, we had, I say we, as I was the licensed research and cultivation facility to do the wraparound that's required to do illegal hemp grow, licensed by the DEA, tested by the DEA, all paperwork done. Was in the middle of the night destroyed by 2 D8 tractors because the sheriff decided that Prop 64 didn't belong in San Joaquin. Now, I have no big financial loss on this, other than the fact that I just put up $50,000 to hire a legal team because the owners of this were 3 Native American families that have been farming on this particular piece of land for 100 years. Wow. And I was so incensed that law enforcement, where the war on drugs was supposed to be sort of over, and now they're still tilling under industrial hemp. We still have a problem with this. I filed a $77 million lawsuit in federal court, and as soon as my private investigator reports come back, we're going to be filing a RICO case on the sheriff, on the city council members, not the council, the supervisors, and we're going after all of them on a personal basis. We have case law that we think eliminates their immunity. I'm suing them all individual. Somebody needs to teach them a lesson. We can now grow this product. Thank you.
Thanks very much.
Mark Whitlow, Marine Analytics again. I want to bring up the possibility of spending some of all this billions of dollars we're making on cannabis on doing research on the toxicology of the cannabinoids and the pesticides associated with them. I'd also like to see this body set pesticide use for cannabis in California. Thank you.
Thank you. Seeing no more public comment, please, sir.
The reason that we're pushing for standalone legislation for this cannabis space mainly is because that Prop 209 it creates challenges when attempting to craft diversity and equity language for the state of California. The only other model that we probably need to try to look at is the California State Contract Certification Process, where that 10% of allocation to go towards disadvantaged business enterprises is in effect. And that is because on the federal state level is aligned with the state of California, i.e. Department of General Services and the High Speed Rail Initiative. So if we can take some language out of that, model that, as well as some language that we've done in Florida and Pennsylvania, I think we would do well for diversity. Thank you.
All right. Seeing no more public comment, we will move to agenda item 12, opening the floor to our committee members for any future agenda items you'd like to see. Ms. Jacobson?
I move to add further discussion on the testing issue.
Thank you. And we don't have to entertain official motions for this. We'll hear comments from the members and note that for our future meetings. Thank you. Mr. Woolsey?
It's just a request that if there are PowerPoint slide presentations at future meetings, we either have handouts or everybody can see them on screens on the committee. Thank you.
Definitely. Thank you.
And I would love to see more discussion around bifurcation issues in relationship to cultivation and how the A and M licenses overlay or don't overlay. I thought that was resolved.
Any other comments from our committee? Yes, Dr. Cermak?
I would like to see more discussion of the question of how do we adjudicate the question of what is attractive to youth, to children. We don't have standards for that yet.
Thank you.
I'm
Dr.
interested in how we are going to proactively educate the public on the cannabis issues surrounding toxic amounts, prohibiting children, and how we're going to market that message to the state.
Thank you.
I think I'll just put, it obviously came up a lot today in the context of different things, but the issue of equity, barriers to entry, limitation. I know there are legal limitations on what data can be collected, but what are those and what can we creatively do otherwise as a topic of discussion for its own.
Thank you. Yes, Ms. Peck.
I would like to hear more about the testing also. And I think what would behoove the board or the advisory board is that if we have some idea in January, some of the roadblocks that we're going to be facing when this is rolled out. And I think testing is probably one of the things that I hear a lot of. There's not going to be enough labs. You know, how are we going to answer these questions? And I think it would be nice for us to kind of have a sheet knowing from all of you, from people that have contacted you, what some of the roadblocks may be in January. So we're prepared. And we have an idea of what's ahead. So thank you.
Thank you.
One other thing is the issue of local enforcement, and how's that going to be carried out?
I do think that a couple people pointed out that, you know, $3,000 of value for delivery services, it creates a lot of inefficiency, possibly congestion and additional air pollution, just lots of things that people should probably look at.
Thank you. Ms. Jacobson.
Well, just taking into account what we heard from the public, it seems like banking might be an issue we should discuss at some point.
Thank you. Mr. Stevenson.
Yes, I would, after realizing that the Department of Corrections has used firefighters to fight fires this summer, I believe that those individuals that take on difficult jobs such as that should be able to matriculate into the industry once they're paroled. And I'd like to see some sort of funding to assist in that to reduce recidivism.
Ms. Huffman.
I don't know if I heard, you were mumbling over there, so yes, I'm going to repeat what I hope you said, is that we put some time in on the equity framework. Is that what you said?
I'm sorry, what?
Thank you.
All right, you said it.
Any other comments from the committee? Great. And any public comment on agenda item 12? Great. Moving on, we're on our last agenda item number 13. Before we adjourn, just want to share a few reminders with folks. One, if you provided public comment today, please remember this is not official comment in response to the emergency regulations that were released today. You have a copy of the Bureau's regulations. The first page provides instructions on how to provide official public comment in response to the emergency regulations. And we'll also continue to communicate that out through the Bureau website and our communications team. Also, I'm happy to announce that the 3 PowerPoints that were presented today by the 3 licensing agencies are online right now. So please feel free to go onto the Bureau website where you can access those PowerPoints that provide a summary of the 3 regulations that were released today. And just a few reminders to our board members. We will, of course, send you communications and reminders for our first meeting in 2018, which is on January 18th here in Sacramento. You have a board packet in a manila envelope that was handed to you today. We'll communicate further on getting that from you and the required trainings per the Department of Consumer Affairs. And finally, the Bureau staff will be recommending in January a set of bylaws for the committee to approve, modify, or reject, which will likely include the opportunity for members to nominate and vote on a chair and vice chair to lead this committee. Though I loved my job today, the chair would take over this role and moderate the next meetings for the committee moving forward. Any last questions, Mr. Nishida?
I just have a last suggestion, and this is for the Bureau. It might be beneficial in advance of the next meeting in January to prepare a statement for the website and also to hand out at the meeting so that people who come from the public understand the role of the advisory committee. A lot of people came with questions for us, not realizing that we probably have the same questions that they're asking and we don't have the answers. So that might, help people understand when they come up why they're giving a comment and what their comment is designed to do.
Yes, and we did pass out an overview document of the committee, which included this statutory language setting up and establishing this committee, but we'll continue to point that out to the public, of course. Great. Any last comments or questions? And our USB card for our members, that's for your use for all of your committee materials that we'll be sending out to you over the next months and next year. Please take them with you. We'll be sending instructions on how to fill them out, and there will be a number of required trainings. As a new member at DCA, all the trainings will be online, and we'll share all that information with you via email. Yes, I'm sorry. Please, the oath is in your blue packets. Please do sign it and leave it on the table. We'll pick it up. Congratulations. I'm very honored to be working with you all. Thank you, everyone, for attending. And 4:31 p.m., we are adjourned. Thank you so much.